May I have this, Your Lordship?
Yes.
With the complaint on the other side, I beg to mention item number 22 and 23, Your Lordship. Please kindly pass over for day, Your Lordship.
Why?
Today we have some difficulties.
22 and 23?
Lordship?
What is the method? 2014 method? What's
Yes,
there?
Lordship. Yes, Lordship. We have some difficulties today, Your Lordship.
What difficulty? What is the method?
Uh,
2014 method, sir.
yes, Lordship. We are standing counsel for APSC, Your Lordship.
Huh?
Standing counsel APSC, Lordship. Have
These are listed for dismissal.
no, Lordship. I have no idea, Lordship.
Who is for the petitioner?
Petitioner's Lordship, we have submitted a slip, Your Lordship, adjournment slip, Your Lordship. Second consent.
Who is you? Are you seriously? Is there any issue to be determined?
Lordship.
Any live issue to be determined?
No, Lordship.
The appointment of what?
Lordship, I have no any instruction.
If you have no any instruction, don't make a mention. You
Lordship,
tell
we have submitted the slip, Lordship.
No, it's okay. You tell.
Lordship, Mr. TJ Mahant
you
had some
info-
difficulty. His father's death anniversary today, Lordship. That's why he
It's okay. We'll see. He may not be required.
Lordship, that
Have you seen the last order?
no, Lordship.
So check it out and make a mention. And go through the
Lordship,
petition.
probably petitioner have would not become Lordship with the
That's why I'm saying you just inform him. We'll take it out. 2014 method. You may have to dismiss also. We
Lordship.
may have to dismiss also.
Lordship, the dismissal would be difficult. Lordship, we have submitted slip there. We have taken the consent from the.
Are you for the petitioner?
No, Lordship.
Then,
Lordship, we have.
if it is dismissed, what's your problem?
No, Lordship, we have taken consent on the slip, Lordship, for taking time, Your Lordship.
From where you have taken the consent? Who is the petitioner?
Slip, that slip competition.
So who is the petitioner? Give me the file. It is shown to be for dismissal. Last order. Sir, who is the counsel for the petitioner?
Lordship, I have no idea, Lordship.
You said you have taken a consent.
Lordship, we have submitted the slip, Lordship.
Forget about the
slip,
slip.
Lordship.
I'm asking who is the counsel for the petitioner. You have said you have taken a consent.
Your Lordship, we have. Wait for Lordship. I'm.
अरे यार सुबह सुबह यात्रा मत खराब मत करो. Last order it said it should be listed on so and so under the column with a remark for dismissal. No adjournment. We'll see. Mr. You be there.
Yes.
This last order, this court had passed that it should be listed in the column for dismissal.
That's.
There's a reason.
Yes, Lordship.
If you have taken a consent from
Yes.
your colleague
Yes.
for the petitioner,
Yes.
you just inform him to take a pain to appear for 5 minutes. All right. If he really wanted to pursue, we'll adjourn the matter. That's the reason I'm not granting it. You inform him, huh?
May I please? I beg to mention on item 4, madam. We need to file affidavit in reply in item 4.
Item 4.
Yes, sir. It can come after 2 weeks, madam.
What's this?
We need to file reply.
Mr.
Be booked.
Because learned counsel for the petitioner permits that he may be fresh for 2 weeks time to file affidavit in the reply. Praise the Lord, list after 2 weeks
Obliged.
for filing, so as to enable Mr. Lucas to learn counsel to file for filing affidavit.
Obliged.
No, enable Mr. is to enable Mr. to file affidavit. Huh? Yes,
May I please, Lordship?
yes.
Item number 12, Lordship, I have filed one IA for date correction. Lordship, I may be allowed to take this matter record. Lordship, I may be allowed to call for record, Lordship, to take with this matter. IA number is 81025
IA for what?
for date correction, Lordship.
What date correct?
Matter is related to the seniority, Lordship. That is interplace, Lordship.
Call it, call it.
Late this is an option.
Yes,
My lord, with the consent of other side, I beg to mention item number 28, my lord.
20.
28, my lord, 28, my lord. can it be taken up next week or after a week, my lord?
Why?
My lord, because of my personal difficulty, my lord, I'm paying
What is the
Echo-
matter?
28, my lord.
This has been listed on your, no.
Mhm.
What is the matter?
My lord, it's regarding, my lord, direction to the responding authorities for allotting mark sheet, my lord, original pass certificate of MBBS, my lord.
Why?
My lord,
How can direct that?
because all our course were given mark sheets, my lord, original pass certificate by the university, my lord. Only in her case, my lord, it was stopped.
Any affidavit has been filed.
Yes, my lord, affidavit, and we have also filed this,
Saying
like,
what?
Yes,
yes, my lord.
Saying
I'm appearing on behalf of the respondent.
So,
There is a CBI case pending against the writ petitioner lordship. That is why provisional certificate has already been issued. Original has been withheld, lordship.
Original has been, my lord, to all the similarly situated person, the university has issued, my lord, the original certificate only in my case, my lord.
what about those, they are under the CBA,
Yes, my lord.
Those
Ye-
persons
yes,
are also-
Yes, yes, my lord.
huh?
We were similarly situated students, my lord. Yes. So, my lord, only 1 week after refusal.
He is having some personal difficulties
Next
today,
week,
lordship.
if
No,
the-
no, forget about, it is only for issuance of the certificate.
yes,
Lordship.
If you have issued to other similarly situated persons, why not to him?
That will depend on the outcome of the CBI case.
So why you
lordship.
have given it to the other accused,
my lord,
other persons who have equally, they are also accused?
Ye-
We have been authorized by the state lordship.
Huh?
Education department is there, lordship.
How can you do that?
No, we have been authorized by the state. Only on their instructions.
Only
we have
for
issued.
the, only authorized to issue certificate only to other accused persons?
Oh,
No.
we get that against.
no,
There
no,
is
no,
no
no, they are,
pending.
no, all of them are
So-
similar, yes, yes. It is
They are
on,
also accused in the case.
yes, my lord, it is there on record.
Lordship.
Yes, my lord. Yes.
I am appearing on behalf of the respondent university, lordship, Dibrugarh University, respondent number 5.
Yes.
University has issued to, my lord, my coursemate also. Only in my case, there's,
Well, forget about the course mate.
yes.
Are they also accused in the
Yes,
CBI?
my lord.
CBI
Yes,
case?
my lord. Yes,
You are also
yes,
accused.
my lord. We all are facing the trial, my lord.
Hmm.
And because of the court's direction, my lord, our registration was granted by the university. And thereafter, we applied for, my lord, we paid for our issuance of original pass certificate that was given to my coursemate. But in my case, it was not issued, my lord.
What is the case against you?
It was stated that, my lord, the admission which we in the year 2002 and 3, the admission was taken in a fraudulent manner.
So, until the time it is settled,
So, my lordship also knows, my lord, that
provision has been given to you, is not it?
provisional,
Yes,
my lord,
lordship, provisional provided.
with the provisional certificate, my lord, we cannot do anything.
Hmm?
I cannot do anything, madam, with the provisional certificate.
Your degree itself is under cloud. It's under CBI investigation and it's in the trial now. What is the stage of trial? It is a trial
Probably it
stage.
is in the stage of
That
evidence.
is what, my
lordship.
lord, only perhaps, my lord, out of 42 witnesses, 2 only examined, my lord.
Hmm.
Only 2.
So,
That is why I also, my lord, I asked for that instructions, my lord. That is why, my
on the
lord,
prayer of Mr. So-and-so, learned counsel for the petitioner, item,
item 28, my lord.
list this matter after 4 weeks.
My lord,
In the meantime, the petitioner may obtain status of the trial
trial, my lord.
against the petitioner,
My lord,
as well as to the other similarly situated accused. List of
not 2 weeks, can it be possible, my lord, after 2 weeks?
4 weeks.
Kindly, my lord.
May please your lordship. Lordship, I beg to mention for item number 20 of today's daily list.
20,
Item number 20, lordship,
20.
20, yes.
What is the matter?
Lordship, matter is regarding the,
It's listed for orders. We'll see what order has to be placed.
lordship, the,
You be there. Next.
lordship, the council has some difficulties, so we have
We'll
taken-
see what order has to be passed. You are for petitioner.
No, lordship, I am for the respondent.
Petition.
So
Lordship,
you
we have
you
taken
have
their
no
consent.
objection.
Yes, Lordship. They have taken the consent, Lordship.
On the prayer of Mr.
Yes,
So-and-so,
Sinha.
and as consented by MS so-and-so, learned counsel for the petitioner.
Lordship,
You are for respondent number?
Respondent number 6.
Lordship, interim
As
is there.
consented
Lordship.
by so-and-so, learned counsel for the petitioner. List this matter after 5 weeks.
Lordship, interim is,
Order
Lordship,
passed
5 weeks
against
will be, lordship,
4 weeks.
2 weeks, lordship,
4 weeks.
2 weeks, lordship,
4 weeks.
4 weeks, lordship.
Ablash, Lordship.
2025.
May I please, Lordship, Lordship,
Yes.
yesterday I have filed IA for correction of order, Lordship. Lordship, kindly list on tomorrow, Lordship.
Hmm?
Tomorrow, Lordship.
Next week.
Lordship, item number 29.
20?
29.
Yes.
Passover for
Yes.
the Passover for the day.
Why?
Uh,
2018 matter.
Yes, yes. Yes, sir. 29. 20.
Why?
Lordship, file some misplaced.
Hmm?
File misplaced, sir.
Are you sure?
Yes, Lordship.
Not bluffing.
Yes, sir. No, Lordship, misplaced, that's why I cannot appear.
Are you not bluffing? Or fucking around?
Lordship, no.
Anyway, Mr. So-and-so, learned counsel for the petitioner,
M.A. Ahmed.
submits that he has misplaced his brief. Mr. Therefore, prays for adjournment of the matter for 3 weeks so as to enable him to reconstruct the same. List of prayer is allowed, list after 2 weeks, 3 weeks. What is this?
May it please your lordship.
Yes,
My lord, the matter relates to, my lord, non-provincialization of the service of the petitioner, my lord. On the ground that their names are not appearing in the UDIS court, my lord.
yes, Mr.
Yes, sir.
It's covered case.
Yes, my lord.
Yes, my lord.
We already covered.
It has
this.
been taken to appeal.
Yes, my lord.
Yes,
No, my lord, no.
they have accepted it. This is the judgment.
It's okay, judgment is here. That Kishore Kumar Nath.
Yes, my lord. On the earlier occasion, my lord, I handed over a copy to the honorable court, my lord. My lord will, the relevant paragraphs, my lord, paragraph 9 and 16 to 19.
16 to 19.
Paragraph 9, 16 to 19.
We will dispose it of
My lord.
Yes, my lord. Oh, thank you.
heard Mr. R.M. Dekar,
Yes, sir.
learned counsel for the petitioner.
Petitioner, my lord, in item numbers 32, 15, 16, and 33, my lord.
Huh?
14, 17, 18, and 19. All are similar.
But different schools,
Same, my lord.
same school.
Same. School is different, my lord, but the, my lord, the issue is same, non-provincialization due to non-appearing the name in the UDIS court, my lord.
So in that case, you write, what are the items?
My lord,
32,
I am
huh?
appearing in item number supplementary list 32,
Ah,
33, main list 15 and 16.
Then
Number 14,
14,
17,
17,
18, and 19.
18 and 19. All together, huh? And Mr. N.J. Katinia, learned counsel for the, learned standing counsel for
Secondary
Secondary.
education.
secondary education, government of Assam. And all the response. Next page. As these repetitions involve similar facts and law, the same are heard analogously and disposed of. At the motion stage, it's an admission, motion stage.
Not all are in motion. sir.
Item number 32 is
It's
in
okay,
motion, my lord.
you know, disposed of by this common judgment and order. And by this common order at this stage. Next page. The writ petitions, the writ petition have been instituted challenging the rejection of the um, you have not said anything in your prayer.
My lord.
It's
Our
only
prayer,
for provisionalization.
yes, my lord, our prayer is to provincialization, my lord.
Instituted, praying for provincialize the service of the petitioners as teachers in the different schools of which district? All
Kamrup
Kamrup,
district, Kamrup district, my.
all Kamrup. In the, no, in the district of, in the different schools, in the district of Kamrup, then what are the districts of Borpeta, Kachar, and one Demaji
Dhemaji district.
and Sonitpur. By seeking a similar benefit, a similar relief. Of the order that it. Which order? No, of the similar relief, huh? Of the judgment and order passed in Kishore Kumar, a bunch of writ petition. Leading case being Kishore Kumar Nath Basis, State of Assam, reported in 2023, SCC online. GAU Guwahati 1487, huh? It's here. In writ petition, first one, huh? In WPC 6368 of 2024. What about this 33, item 33? It's
Yes,
also same school,
Yes,
different
sir.
school,
Item 33, 15 and 16 are the same school, my lord.
same school. You are working as,
Working as teacher, my lord,
then you write
as lecturer, my lord, not
In
in
which
the
position?
lecturer, my lord.
in writ petitions. In WPC, yeah, you write item 32, 33. 16 and
15 and 16, my lord.
15 and 16, huh? Same.
In 32, I am the lecturer of Department of Geography, my lord.
Yes, correct.
Right.
The petitioners were appointed as lecturer and teachers at Kalitola, Katmani Anchalik Senior Secondary School.
Yes, my lord.
Listen. The district scrutiny committee. In terms of the provisions of Assam education within bracket, provincialization of services of teachers and reorganization of educational institution within bracket, a bracket clause at 2017. Bracket in short, the education Assam Education Provincial Institute, 2017, bracket clause. Recommended for provincialization of the services of the petitioner as teachers and the lecturer,
Teacher, my lord, now teacher or tutor, my lord?
teachers,
Teacher, my lord.
public tutors. However, the service of the petitioner services of the petitioners have not been provincialized on the ground that their names are not reflected in DISC code. Next step. In other. Yours is same. Yours is 33, 34,
32,
15 and 16.
32, 15, 16, and 33.
You take all, huh? All schools same in the district. Huh?
The 33 school is different, my lord. In item 33, the school is different, my lord. School's name is Novosakti Senior Secondary School.
The school name, then in that case, next para, in WPC 3378 of 2023. You just give the number
Yes, my lord.
of the writ petition,
And the name of schools, my
name
lord.
of the school.
Yes, my lord. I'll hand it over my lord, after some time.
Then in
Number 14, madam, the petitioner is the head teacher.
in writ petition, so and so, huh?
Okay, I is madrasas.
Ah. If I know the same, I call that so and so. Same, huh? Only the different district and the school will be different. Same one, there. Your case is also been recommended.
Right, delegate.
The next. The Mr. RM Dekha and MS
A. Buzar Borga.
A. Bujar, MS A. Bujar, and council for the petitioners have submitted that under the Assam Assam Education Provincialization Act 2017. There is no requirement of reflecting the names of the name of the teacher, tutor of the Benson Senior Secondary School, all senior secondary schools
Yes, my lord. Also.
in the DISC for provincialization of their services. What is DISC? Full form? I forgot.
Yeah. District Information School Code, I think. I'll check it sometime.
District information something,
Scrutiny Committee.
school enrollment something like DISC. You find out
Yes, ma'am.
what is this. May
District
not be
Information
relevant,
System
the
for
full form
Education.
May not be relevant, but we.
My lord, District Information System for Education. Paragraph 3 of that judgment, my lord, we are relying on.
Yes.
District Information System for Education.
Therefore, they submits that the rejection of the case of the petitioner for provisionalization of their services on the ground of not reflecting in the DISC code is not tenable. And as such, the direction may be given to the direction may be issued to the respondent authorities to provisionalize the services of the petitioner in accordance with the said. Yes. By next paragraph, the learned counsel for the petitioners by relying on the judgment and order of this court, order of the honorable bench of this court. In the case of Kishore Kumar Nath and others versus State of Assam. And other batch of root petitions reported in 2022 submits that the judgment and order equally covers the case of the petitioner in the present case. Mr. Next paragraph. In the Catania, learning distinct concept, elementary education,
Secondary education.
the secondary education. Fairly submits that. The judgment and order and referred as relied on by the learned counsel for the petitioner. In Kishore Kumar Nag within the Supreme. Indeed, covers the case of the present case. Therefore, he would not have any objection for a objection to the grievances, objection to the prayer made by the petitioners in the present proceedings. Next paragraph. Having considered the submissions of learned counsel for the parties and also perusal of the
No.
judgment and order in so and so, Kishore Kumar Nag, so and so, so and so. I'm also reviewed the above case. Squarely covers the case, squarely covers the present case. Mr. Thus, it would be appropriate to provide a similar relief to the present petitioners.
Item number 33, no? 33.
Mr. The escort, what is the relevant paragraph?
Paragraph 9 and 16 to 19.
The next thing, a reference may be, next paragraph, a reference may be made to the relevant paragraphs.
30 to 33 all
Of the case of Kishore Kumar so and so, not when the case of, which is reproducing in Viram Bill.
14 to
Para 9,
Para 9, 14, 16, 17, 18, 19.
fourteen,
16, 17, 18, 19.
14, 16, 17, 18,
And 19. ma'am.
Next paragraph, I mean, very jealous. Above. Above judgment and order. And also considering the submissions of fair submissions of learned person to the parties. These batch of writ petitions are disposed of, providing the similar relief to the petitioners as provided in the in the case of which is super. Accordingly, it is directed that the director of secondary education department. No, accordingly, the director of school education, secondary education department, government of Assam, is directed to consider the case of the petitioner for provincialization of their services as teachers, public tutors, by making necessary verification in as per the provision of the Assam Education Provincialization Act 2007, without insisting upon their names being captured in the DIC portal 2009 and 2010. Yours also a similar year.
My lord.
It's a similar year, 2009 and 2010.
Yes, ma'am.
Is it so?
Yes, 2009, 10, ma'am.
Or prior year, the as provided in the above case, the whole exercise be completed within a period of 6 months from the date of receipt of the certificate for this. This thing. Consequently, the communications passed by the impure communication passed by the Director of Secondary Education Department, rejecting the claim of the petitioner for provisionalization of their services on the ground of not capturing in the DIC form is hereby set aside. Huh? Is there any communication to you?
In my case, there is no such communication, my lord.
What is the copy of all data of the petition? They are only in Dhamagi district.
Then in that case, last one, setting aside with the above observation direction, these beds of lead petitions are allowed and disposed of.
Deeply obliged.
32, 33. What is that? 32, 33?
32, 33, 15, 16. 14, 15, 16.
14, 15, 16,
Made up my
17, 18, 19. You note it down. Huh?
Deeply obliged.
Yes.
Petitioner is the first wife of my deceased husband, my lord. My husband was serving as an assistant teacher of Paschim Jugijan Adarsh LP School under Nagaon district. And my marriage was solemnized in the year 1999. And the private testimonial marriage was solemnized subsequent after me, my lord. And I have no sign. And in the year 2001, there was dispute between my husband and myself, my lord. And I have also filed a maintenance case as well as some domestic violence case. And page 25, my lord, page 25, there is an order passed by the learned court below stating that I am the first wife that has been established. And the private respondent also admitted that though now she has denied my first marriage, but it was established before the learned court below. And ultimately, my lord, learned court below in paragraph 30, in page 32, this is a type copy. Yes, my lord.
Yes.
Last paragraph. Well, after hearing all the parties, I have filed domestic violence case, my lord, dowry case. Page 32, last paragraph.
What do you want?
After perusing the evidence of all the PWS, it appears that the accused looked for
Had married the complaint as per the Islamic Sharia, and Nikah was performed stated by
Then, my lord,
which is admitted by the accused in
my lord, then page 33.
It's okay.
I am
What do
the
you want?
first wife. I am
What do
the
you want?
first wife. My husband died in the year 2021. Thereafter, the second wife somehow approached the authorities. I also approached the authorities. In the meantime, she has drawn some amount. And this honorable court, I ordered that when I approved this honorable court on 11/2022, direction was issued not to disburse any pensionary benefit disregarding my case, my lord.
Your ways to decide the dispute.
My lord, she has now claimed as the second wife, my lord.
Huh?
I am the first wife. So there is no dispute. The honorable court at paragraph 7 held the petitioner is the first wife. Your lordship may peruse that order, my lord, on paragraph, order dated 11/3/2022.
11-3.
Yes, my lord.
The petitioner is the first wife, the respondent is the second wife.
Yes, my
The
lord.
family pension has been paid to respondent by the other. By the.
Therefore, there is a
under the-
stay order.
Yes,
Well, till that, they have not filed any application for the modification of this order. And after the order was passed, their payment has been stopped. And now they have claimed that my marriage was nullified, according to them. But when
you
the,
share 50-50.
my lord, as per the division bench, full bench order, my lord, I am ready to pay to the unmarried daughter of the second wife. I'm fairly submit, but the second wife is not entitled, my lord.
Under which law?
My lord, as per division, full bench order, my lord.
Ah,
She should approach the civil court and she can claim maintenance, my lord. Otherwise, she cannot claim anything from me, my lord. It is a settled position. In case of Mohammed and Lawman. Paragraph 22 and 23.
paragraph.
Last two paragraph 22, 23. We further held that family pension being payable to the eldest of the surviving widow. I am the eldest surviving widow, my lord.
We further hold that the family pension being payable to eldest of the surviving widow or wife does not mean that the uncle family pensions are paid with the personal property and the rest of the surviving widow or wife in the family pension is also payable with the hand of the eldest. To the benefits of family pension. Yes.
Therefore, my lord, all the compassionate family
From
pension.
whom she would be, from whom she would claim, second wife would claim maintenance.
From the first wife, my lord,
Huh?
provided that her
When
marriage,
the husband died,
from the first wife, my lord,
how can
my lord,
how
department
can
will,
she claim a maintenance
My lord,
from the
department-
first wife?
department will issue PPO now, my lord, compassionate family pension in favor of the first wife.
Otherwise,
that-
they officially, your name is not there.
My lord, officially,
In
I
the
think they
service
can,
book.
officially they cannot do, my lord.
Your name
Office-
is not been,
My lord, subsequently they have, my husband has replaced, but in all the documents, there are so many documents.
not
in-
document, service book.
My lord, service is not mandatory, my lord, because this is only
I'm not
nominee.
asking whether mandatory, not mandatory. I'm asking the service book, whether your name has been
No, my
recorded
lord,
or
no.
not.
My name has not
Not
been,
even once.
my lord, my name was not reflected. But it is admitted that I was the first wife and my marriage was solemnized in the year 1999 and her marriage was solemnized in the subsequently. And the learned court below, though the husband of my husband disagreed the marriage, but it was,
Better. You are not disputing that she was she is a second marriage, a second wife.
now they have claimed, my lord.
You distribute 50-50. You share 50-50.
Not as per division bench order, full bench order, my lord,
Huh?
that PPU should be issued in my favor.
Yourself, how do we know
And
your name is not recorded in the service book?
my lord, I will give some share to the
50%.
my lord, unmarried daughter, my lord, to the unmarried daughter. She is eligible. Otherwise, second wife is not entitled. As per rule, my lord. I am agreeable to pay some share to the unmarried daughter of the second wife. Wow. Of its own volition. Fundamentally, हमें डिवोट करना है.
Yes.
My lord, second marriage is not permissible as per law, my lord, though they belong to Mohammedan community, my lord. Then also, my lord, they have to obtain permission from the,
We're not going in.
yes, my lord. So it is established, my lord, I'm the first wife, she is
Second
not,
wife,
is not entitled, my lord.
maybe due to differences between you and your husband,
Yes, my lord.
she may contract into a second marriage and her name is
Malad-
not recorded.
My lord, I have been living with,
Nowhere, before that also nowhere your name is not recorded.
my lord, I have been living with my husband, my lord, till the date of his death, my lord.
Yes.
And department has not clarified their stand, my lord.
We'll
Till
see
today.
what is the
Hello.
No affidavit has been filed.
All the certificates of name of the kind was there. Personal kind is very already in 23 and 2023. 23? 8, 2023. In this, shall apprise the court as to whether the pension pay order has already been issued to the respondent to the pension proposal. Forwarded the pension insurance. Nothing further on this, no pension against some covered provision. Yes,
May please, your lordship.
so what is the instruction? You have apprised, but then you have been allowed to take instruction. On the next date fixed, what happened thereafter? Next order. What is the next order? There is nothing, no next order. Orders are there, but no effective orders on that. On the next day, Director of Pension shall apprise the court as to whether pension order have already been issued to the respondent number 9 in terms of so and so. Whether it has been issued.
I cannot, there is an interim order.
It is seen that because the instruction I have placed before the survey for on the day, it is seen that the deputy inspector is like 5 numbers,
Amar is like,
second wife of the late teacher.
Communicate to-
From our side, I have placed instruction that all the side record, the name of the restaurant number 9 was recorded. Including the death certificate and next up, everything. So recording the proposal was forwarded from our side as per the.
Yes, my lord. May please the lordship. My lord, I am appealing for the response number 9. As he stated, the question of first wife and second wife does not arise at all. I am the only wife of the person concerned, Dr. Hussain. I have submitted the marriage certificate, which is at
You are
annex.
saying that he is not first wife.
His no marriage was performed.
See, the
yes.
court has recorded.
I
our
am,
court
yes,
has recorded.
I am submitting from the records. Annexer A.
It's
at
okay. The court has the law, the trial court in the other case
the-
recorded that as per the prosecution witnesses, is the first wife. She is the first wife.
My lord,
in a
in
different
this,
proceeding.
in this context,
that
I-
is order that has been interfered with.
in this context, I beg to submit before your lordship that your lordship may peruse Annexer A at page 72.
Hmm.
This is the order from the record. It is stated that one commitment was executed on 12/12/99. But that was cancelled and no performance of marriage was done. It is specifically stated in this case. And accordingly, she is not the wife. And which was cancelled, marriage was cancelled on 10/1/2000. And the judgment on which he relied, it is subsequently filed by the case was subsequently filed. In that time, she was not in the Kabinama was not valid. No marriage was performed. That fact has been revealed by the judgment itself. Yes, my lord. Your lordship may kindly peruse the judgment from which it reveals that Kabinama, in the evidence it is stated that Kabinama was cancelled. No
What is
marriage
the-
was
what is
performed.
the final-
Your lordship
What
may
is the final conclusion of the trial court?
uh,
Final conclusion of the trial court.
conclusion, the trial court concluded that and convicted me under section 498A by its judgment. But that was what happened after that, I do not know. But in evidence, I have stated, specifically stated,
You may have said, what was this conclusion?
conclusion is the criminal court concluded that she is the wife and he has done cruelty to the complainant. But that the cancellation of the marriage was suppressed by the complainant. At that time, no marriage was subsisted.
Who has filed this? Who has approached it?
The
17.
writ petitioner has filed it.
No. So last Kabinama between
Kabinama was filed. It was filed-
the road district was executed, but the marriage was not read over and still not
executed
been
fraudulently
filed. Today the
by fraud.
bridegroom.
By fraud, using
Huh?
fraud. Yes, it is specifically recorded.
Today the bridegroom,
Yes.
bride or the groom?
Come to
my
Kabinama
office.
was filed by the bride, not myself.
Today the bridegroom came to my office and submitted an application in my office stating that said Kabinama was executed fraudulently. Huh?
Kabinama was the deed,
Who
but
came?
the utterance of the
Who
words,
went to the office? of
My
the
lord.
marriage?
my lord,
Who went?
I-
Who went to the
I
office?
approached the Qazi and he filed a petition.
Obviously,
Yes, my lord.
because
That
there was a case
fraud has
pending.
been used.
There was a case pending that point of time.
No, after that, it is
is a-
order was
it is a-
10/1/2000 and case was filed in 2001, subsequently filed. And that fact was suppressed by the complainant. She has,
Who has suppressed? This is
The-
your,
the
you
writ
have
petitioner,
got it.
the writ
cancelled
petitioner,
and,
complainant,
okay,
complainant.
see
Yes.
the-
complainant has suppressed the fact.
Who has got it cancelled?
Qazi,
Who has got it cancelled?
husband,
Husband.
yes, madam.
So how do the wife will know that whether this has been cancelled or not?
No,
You
was-
have again to show fraudulent act, you have played fraud.
I am submitting from the record
This is the
as it will.
record which shows that you have played fraud.
Qazi was
Either there is
satisfied.
it's
Qazi
okay.
was
The
satisfied.
trial criminal court has accepted that he is the first one.
However, the mandatory words which are to be uttered for performance of the Muslim
That
marriage.
you have obtained by playing fraud. Because you are not having a good relation with your wife.
Yes.
Consequently, which led to filing of the criminal case.
I have filed my petition.
You
madam.
got it cancelled?
Yeah,
You got it cancelled, page 72?
page 72.
Who got it cancelled? Wife or you?
I have filed my petition. Well, Qazi,
For cancellation.
Qazi.
For cancellation.
Oh, yes,
You went
madam.
to Qazi,
Yes,
got it cancelled, right?
yes, cancel it is your lordship, I am reading.
I have read it. I'm saying
Yeah.
you have got it cancelled
Yes,
without her knowledge because you are having not a good relation with your husband.
however,
Wife.
the fact is that no marriage was performed. That is
We
a
don't
fact.
know. We don't know. You have unilaterally gone there
But
because you are not having a
but
good relation.
record reveals it.
Record reveals on your flying fraud, sir.
I have not used for any fraud.
So
She has fraud.
you are not having a good relation.
But
and you just went to the Qazi and got it cancelled.
my lord, however,
How can this be permissible?
on the other hand,
No. Now, in the criminal proceedings, trial court has held that she is the first one. What have you done to that? Any appeal has been filed?
No.
I have no knowledge, my lord.
Which order, which documents should be relied? It's a documents obtained by you fraudulently by getting it, the cancel the Kabila Nama
Yes.
unilaterally or the order of the observation of the court. Which documents should be relied on?
My lord, regarding Kabinama, I will rely upon
How many,
two sentences.
how many sons and daughters you have?
I have no son.
Daughters you have?
She has two daughters. Both are,
What about you?
I have no son.
Okay.
My page 33, that
You have no issue, no children,
no children.
no child.
My lord, page 33,
We'll
that
grant you sometime. Work it out. 50-50. Forget about the law.
I have to take
I
instruction.
mean, forget about technicalities of the.
No, it is
My
not
lord,
acceptable.
regarding Kabinama, the Kabinama was
Forget about
registered.
it.
That has
I
been
granted
admitted.
you-
More, what do you know?
Yes, mister,
Yes, my.
talk to your client, 50-50. Family pension 50.
Yes, my lord, I shall talk to her.
Will not at this stage, since
What is her
you are the first
instruction?
wife,
I shall
she is the
place
second wife,
before your
you are not
lordship.
questioning his marriage also, right? You are relying on the full bench or division bench
My lord, the
on
Kabi-
reference.
my
So
lord, that
that's why I'm saying, since you are not disputing the marriage, second marriage, right? And since your name is not been recorded in the service book, we don't see any fault on the part of respondents. Therefore, it's a family pension only. Move
compensation.
ahead, move on in life. Unfortunately, your husband has died 50-50.
Your lordship may grant sometime.
Will grant. Will not go into the technicalities of the law. All right.
I have to take instruction.
Otherwise, rule 143, this full bench or the division bench has clearly said that second wife is not entitled. Right? In view of this rule 143, it's a full bench or what? Yes, full bench. Second wife is not entitled. But the advantage you have is that your name is recorded in the service book. So obviously, whose name is there, authorities will forward the.
Kindly adjourn the case today, my lord.
Sincerely, you make an endeavor
My lord.
to convince your client, because these are, let the, I mean, soul of your husband rest in peace. Let the soul of your husband rest in peace. Both of you.
Yes.
Both the wives.
My lord.
So make an sincere efforts to convince them to share it equally 50-50. All right. Or Mr. So-and-so.
Answer.
Petition. And Mr. Sir, your name, please. Can you record your name?
My name
Can you
is
record your name?
DK Kotoki.
Okay. Okay, learn consult. 1, 2, 3. Just right. Chronologically.
I'm for respondent 3.
P.N. Sharma. For respondent number. Learned State Council. For respondent number 1, 2. Then
I'm for 3, accountant. Is it 5?
I am for the respondent 9.
yes. After hearing the matter at some length, come on. Considering the issue involved, which pertains to
My lord.
payment of family pension claim and claims by the first wife and second wife of late, what's the name?
My lord. Husband and Lutfur Rahman.
Huh?
Lutfur Hussain, husband, and my name is Safiyan Nasar. Lutfur Hussain.
This is husband, namely late Lutfur Hussain. This court is a review that and a reasonable opportunity to the parties to be granted for the interest of justice, accordingly, the learned counsel for the parties are granted 3 weeks' time. 3 weeks' time.
Well,
So it's to enable them to make a sincere effort to come to to settle the issue between the first wife and second wife. So, family price. Right. List after 3 weeks.
well,
We're expecting that we'll come up with positive.
whatever the party concerned shall instruct me, I shall submit before your lordship.
Use your craft.
My lord,
Use your best craft.
I shall try my best.
Mr. Rizal also.
Yes,
Kindly peruse the order dated 25/2, my lord.
25-2.
2, my lord. Directed my lord, regarding my lord, instruction regarding my lord, Annexure X, my lord. Text is that my lord, document verification is going on, my lord, regarding my lord, for further regulation of service of the petitioner.
So what do you mean by that? How many of you are? You
My
are
lord.
20 petitioners.
20 petitioners, my lord, 18 petitioners also reflected in the Annexure X, my lord, but remaining 8 does not, my lord, reflect in the list, my lord. That's why, my
12
lord,
teachers will call for verification
verification. My lord.
and 8 have been left out.
And subsequently come to know, my lord, already, my lord, called them, my lord.
8 of them have already.
My lord.
Then
My lord, John, my lord, in the meantime, my lord, the process is going on, my lord. Then, my lord,
no, if the process is going on, close it.
no, my lord, an
We
instruction.
close the writ petition because verification is going on.
Earlier, my lord,
Without verification, you cannot be. What is your prayer?
we are better to regularize the service, my lord.
Its verification is going on. We'll provide you to come back. If
And
you are
but,
agreed by any outcome of the
And then this is the second
process,
second petition, my lord.
make
This
it
is the-
third or fourth, unless it is barred by law, you are always free to come.
my lord,
We'll
it is
close
the-
it unnecessary. Why should you keep it
my lord,
pending?
it is the second, my lord, writ petition, my lord.
You
In
come
the
back.
earlier-
You come back. You are not objecting to the verification, right?
No, my lord. Yes, my lord.
So we just cannot put a Damocles sword over the respondent all the time.
My lord.
It's kind of that. And when making by keeping it pending, I feel we're making a scarecrow to the
Otherwise,
over
my
the
lord,
respondents.
If, my lord, it is closed, my lord, rather delete the matter, my lord. Again, my lord.
No, we'll say that with the procedure, we cannot, give a
There is
mandate to do it within this period. Certain procedure is to be done, verification and all these things.
My
We
lord,
cannot accept the power of the authority.
Perhaps, my lord, BTC has not.
What is the,
Lordship, we've already communicated regarding this with the department. However, we're awaiting the instructions.
no. We'll consider, I will close it. We'll provide you to,
List
Come back.
after I have to receive instruction, my lord.
what receiving, you said that on last occasion, 12 teachers,
My lord,
8 teachers have been left out.
my lord,
Now you have an instruction that their name have also been included.
included, my lord.
So what remains? We cannot direct in any case because after the verification, certain findings will be there.
My lord.
You may be appointed, you may be rejected.
My lord,
But in these proceedings, if the rejection after the verification is done, we cannot pass any order.
but,
You
my
have to
lord,
challenge that ultimate order if your case is rejected.
my lord.
If not rejected, well and good. You don't have to. But in these present proceedings, we cannot consider the final decision or the outcome of this present verification and the process. That's why I'm saying. Let's be fair, Mr. Pankari.
Even the matter is closed, then again,
We'll give you a liberty. If you will give you a liberty, if any result, if any decision which is not palatable to you, you may approach the court again. All right. So you want to keep it pending.
Lordship, the process is ongoing.
So,
Lordship,
heard Mr. We're closing the matter, providing him a liberty to approach
Lordship,
after the outcome. Well, when we're making an observation that when did he start it?
the time bound,
No, we cannot direct once.
in the
we
year
close-
2015, there is a court order, my lord. That delayed the matter, again filed second writ petition,
Huh?
again filed second writ petition, my lord.
Cannot help it then. Do you agree with me? Or don't you? Suppose you are not agreeable, you are not agreed by the verification process, right?
Right.
If after the verification, if there passes any order or decision
My lord.
which may not be in favor of you,
My lord.
can we decide those decisions in this proceeding? Huh? That's the reason I'm saying. Okay.
My lord.
Heard Mr. K.R. Padgiri, that is counsel for the petitioner. And also heard
A. Bodhakur appearing on behalf of P. Nayak,
so and so appearing on behalf of Mr. P. Nayak, that is standing counsel, BTC.
BTC.
Mr.
for the number 1 and 2.
What do you say, Mr. Sharma?
Also, the matter pertains to BTC, so the verification is.
Okay. Where is that annexure P?
Next, sir, X, my lord. 127 case number.
127. Annexure X series, huh? Your prayer is for what?
My lord.
Your prayer is for what? Your prayer is for what? In
For
this
regulation of the service, my lord.
Yes,
Yes, in the earlier occasion, the
next para. By this writ petition. No, by filing this writ petition, the petitioners have sought for a direction to the respondent authorities to regularize the services of the petitioner as assistant teachers in pursuant to the policy decision taken by the respondent authorities. To the no, teachers as per the policy decision of the state respondents pursuant to the order that is 06/02/2015 in WF in writ appeal number 182 of 2013 and order dated 07/11/2015 in WPC number 6761 of 2015. Policy decision has been taken.
my lord.
During the course of hearing, Mr. K.R. Padgiri, learned counsel for the petitioner, while referring to the page 172,
127, my lord.
127, referring to the annexure X series in the counter affidavit
My lord.
of the respondent authorities, fairly submits that the process of document verification is being held for consideration of the consideration for regulation. Mr. Initially, although he had an instruction that out of 20 petitioners, the name of the 8 petitioners have been left out, comma. Now, the said 8 petitioners have also been included. Mr. Next paragraph. MS so and so learned counsel appearing for so and so, submits that the process of verification no, the document verification is under process for which considerable time may be taken. He submits that all the name of all the petitioners have been included for verification of the documents, which is under process. Next one. Having considered that the respondent authorities are in the process of document verification for consideration for regulation of the services of the prisoner. I am the considered view that no useful purpose would be served by keeping this writ petition pending. Else the grievance raised is for a direction to regulate the service of the petitioners. Mr. Since the petitioners, the learned counsel for the petition clearly, listen. That effort, the learned counsel for the petitioner, Mr. Padgiri, has fairly submitted that he has no objection for verification of the documents of the petitioners for regulation of their services, regulation of the services of the petitioner. Next. Consider the above, I'm of the view that the writ petition may be closed. It's needless to say that the closed accordingly. Same is hereby. Same stands closed, huh? Mr. Next paragraph. Needless to observe that the petitioners the petitioner would be liberty to approach this court again. Approach this court in the event the result of a decision of the respondent authorities are not palatable to the petitioner. It is also expected that the respondent authorities would complete the process within a reasonable period of time. Within a reasonable period of time. Which is responsible. Sustains this time.
May it please your lordship, the matter relates to excess royal amount lordship in case of the petitioner lordship. On the last occasion, a letter was placed before your lordship by the learned standing council, secondary education, regarding requesting to accord necessary approval for waiving the excess royal
Yes.
amount, Lordship,
Lordship,
from
that,
the government, Lordship.
that instruction is on record, your lordship. And we were asked to place instruction as to why her provisional pension has been stopped, your lordship, for the month of January and February. The instruction is that due to non-generation of bill by the principal, your lordship, because he was busy with the ongoing board exams, your lordship. That is the reason.
So
Lordship,
it just
this,
keep pending. This is a part of the simultaneously, it's your job,
lordship,
maybe busy.
lordship, I agree, your lordship.
So what is to be done? What
Direction-
about the decision of the government?
The lordship,
Waiving.
that instruction, lordship, the process is going, it's awaited, your lordship. We have not received any instructions.
So there's no harm.
Lordship,
what
let
is
the
to be-
instruction come regarding that part, Lordship.
Lordship.
And regarding this provisional pension, Lordship, a direction may be given, Lordship. I am suffering, Lordship.
Lordship.
Not Mr. So-and-so, learned counsel for the petition. So we'll close the petition.
Lordship,
We'll close the.
no, Lordship. Let the instruction be come from the government, Lordship.
And counsel for the petition. MS
D Musahari, your lordship.
D. Masari, learned state
Standing council, your
That is
lordship,
standing
for
council.
secondary education.
for secondary education. By placing the communication dated 18/03/2025 from the inspector by the inspector of the
Inspector of
schools,
schools.
DDC, MIL, submits that due to busy schedule of the principal, on account of this Center of SLC and SH examination works 2005, the provisional pension due to the provisional pension could not be completed due to non-generation of the bill by the principal. Which has caused delay in payment of,
Lordship.
caused delay in payment of provisional pension to the petitioner. Mr. It is, next paragraph, it is noticed that the issue of approval for waiving the excess roll amount was is also pending before the
Lordship,
government
government.
for appropriate decision. Next one, considering that the due to busy schedule of the principal, the provisional pension due to the petitioner has been delayed. Now, on account, particularly on account of the examination works 2025. It is provided that the petitioner be paid with the provisional pension by the responding authority within a period of
Lordship,
1 month from today.
15 days, Lordship. 3 months, 15 days.
Lordship, 15 days, because
No, to expedite. It is directed that the responsibility is to expedite the payment for provisional
Provisional
pension to the
pension.
petitioner. And to pay not later than 20 days from today.
20 days. my lord.
20
20
days
days
from
from
today.
your lordship.
List the matter after 4 weeks, 3
Lord-
weeks.
3
Lord-
weeks. then.
I
Obliged.
think virtually your, if your provisional pension is paid, nothing
if-
remains.
Lordship, and if the instructions come, lordship.
They may waive the,
Lordship.
once it is waived.
Lordship.
Yes,
Obliged, your
Obliged,
lordship.
And in this case, Mr. Kane Choudhury will argue this case, my lord, for the time being, my lord.
what is the matter?
Matter relates to, my lord, permission for regulation of the services of the petitioners, my lord. In this case, my lord, the inspector school, this is a case of, my lord, non-provincialization of the person who is working since last 1995. In this case, my lord, there is a, in schools, inspector schools, my lord, invited some schools to open 11th class and 12th class, my lord. And accordingly, there are some process, my lord. Accordingly, the schools were applied for that through inspector schools, and they opened class 11 first. Then automatically 12 also opened, my lord, but their service had not been regularized till today.
So on what basis you are, what is your
Earlier,
basis?
we approached this honorable court because earlier.
What is your basis? Why your services, on what basis your service?
Yes, my lord, because-
regularized?
Yes, my lord, because they were working as per. Oh, I will let, he's coming, my lord.
Sorry.
No, no, it's.
My lord,
তোমালোকৰ পৰা এপিবিড নালাগে
government
নহয় হেৰি কাউন্সিলৰ হয় কাউন্সিলৰ নালাগে গভৰ্ণমেণ্টেটো দিলে আমাক
higher secondary council. But higher secondary council has
Please, not-
approved our case. Thank you.
Are you ready?
Find out if your council, they have not filed. So in fact, we have stated in our affidavit that condition council, their council is required.
কাউন্সিলৰটো আমাৰ পাৰ্মিশ্যন আছে
So my lord, I think their affidavit is required.
Council
Yes,
for
sir.
appearing one.
Lordship.
No, they are saying that the council has already approved,
Yes.
yes approved
That is the dispute, my lord.
but what you are saying? You are saying that until the council approves,
Yes, my lord. We have said
Councillor.
council permission is required, we have said, my lord.
for what? For regularization?
For opening new classes, my lord.
new
Huh?
classes,
For opening 11 and 12.
according
Council permission is required, my lord.
You are saying the permission is granted.
yes
They are taking time to file affidavit, my lord. That's why.
Madam, who is appearing, who is for the council?
Lordship, I'm appearing for TC Sutia, Lordship.
Where is P.C. Sutia?
TC Sutia is another matter on that different court, Lordship. So
We'll take it up at 2.
Yes.
yes
We'll see. If it is required, we'll grant them some time to file.
My lord,
We'll see it. At 2. But it is your job, I mean, duty. You have to be very clear on that.
But as per the Act of 2017, my lord, permission, recognition, all are required to be done before 1 or
Yeah, that's what I'm
6.
saying. You may mistake
Yes,
your
madam.
clear, state your, make your stand very clear.
Yes.
So that whether the requirement of council, the
Yes, ma'am.
requirement of filing counter affidavit on behalf of the
Yes, ma'am.
be necessary or not.
Always.
Yes.
May I please your lordship? In this matter, I am appearing on behalf of respondent number 1 and 2, my lord.
Yes.
The last occasion, honorable court was directed to bring us record, my lord, relevant records, my lord. This was sought for, my lord, but till now we have not received. So I
Oh.
pray 1 week time, my lord, at least.
What is the matter?
The challenge.
My lord, here we have participated in the selection process, my lord, whereby on merit basis, my lord, we were eligible for being appointed, my lord. Here, my lord, respondent number 7 has been appointed in place of Arpita. We are against that appointment, my lord.
They challenge the appointment of respondent number 7, my lord.
Who is less meritorious? Who is less meritorious?
Yes, sir.
By, on what basis?
For that, my lord, the record was called for, my lord.
Heard Mr. So-and-so, let me counsel for the petition. There is a stay of the appointment.
They already appointed, my lord. They challenge.
What about the respondent number 7?
3, 5, and 6 I have appointed, and I have filed the affidavit also, Your Honor. 3, 5, and 6 for the respondent number 3, 5, and 6.
Who you are the department?
No, I'm for the college, Your Honor.
I'm for the department.
Yeah.
So who has appointed? You have appointed.
No, I'm not appointed.
No, who is the
Respondent number
appointed
7 is
authority?
appointed.
No, who is the appointing authority?
Selection, we are appointed the.
Yes,
Yes.
you are the appointing
Yes,
authority.
Yes, yeah.
Heard Mr. So-and-so, let me counsel for you. MS
PR Mohan,
P.R. Monto, let me standing counsel
my lord,
for what?
1 and 2, higher education.
Higher education. Press that she may be granted further 2 weeks time to obtain to produce the record as directed by this court on 07/03/2024. Prayer not being objected with the land council to the unit. And same is granted. This is the matter after 2 weeks.
Obliged.
My lord, may I
The-
pray for a
the-
fixed date, my lord?
In which date?
Fixed date, my lord.
No. On which date? The learned standing council said, produce the, it shall invariably produce the record.
I'll-
Don't miss it.
My lord.
Hmm.
Obliged, my lord.
After 2 weeks.
Lordship, in this matter, we have sent our affidavit for waiting your lordship to the department.
But the issue is very simple, small issue, my lord. The petitioner is claiming seniority, my lord, whether that will be with effect from 94 or 97, my lord. That is the only issue has to be decided. Let them file affidavit. There is some urgency in the matter, my lord, because the present headmaster, my lord, will be retiring in the month of April. So I am the senior most, my lord, if I am considered to be of 94 batch, my lord.
Hmm.
I'm 94 graduate teacher, my lord.
So it has to be decided which year you should, your.
Yes,
seniority should be
whether
obtained.
94 or whether it's 97. my lord.
Any private respondent?
No private respondent, madam, but this, because the Board of Revenue passed an order, in fact, our High Court also passed an order. After that, the Commissioner passed an order, my lord, that is Director, my lord, sorry. Page 1. Lordship may see page 43, my lord. And page 45 is the operative.
Long order.
And the last lordship may see page 45,
Hmm.
considering
The
the date of
reference-
adjustment
Ah,
in the regular sanction post from the date that of centrally sponsored scheme, the seniority of Shri Jatendra Nath Deka, assistant teacher Hindi of Karia High School, is to be considered in the school with effect from 1/4/1997. Whereas I have joined on 8/4/94, my lord.
Hmm.
So the law says, my lord, that it is to be from the date of joining. Not because that post is abolished, my lord, where I've joined. So my service will be continuous service, my lord. And in fact, they have admitted it also, my lord.
there is no break-in service. There is no break in service.
No, no break in service. That is finding lordship may say page 30
Is
here.
it a regular appointment or what?
I'm a regular,
From 94,
94, I'm regular appointment.
regular appointment.
Regular appointment.
Then
There is no
how
break
you
in
have been,
service.
how you could be appointed on a regular post?
Yes.
How-
Lordship may say page,
how-
page 18, lordship may
How
say.
you could be appointed regularly on a post which is which
Lordship sees the appointment letter number,
which
page,
is
18, my lord.
abolished? Why this has been abolished?
page 18, my lord.
Temporary and until for 3 months. Or
Yes.
till the remember.
Thereafter, my lord, page 20 may be seen, my lord. I've extended for in the further until further order. And then, my lord, lordship may see page 22, my lord. My post has been adjusted.
Hereby adjusted in post allotted to the school out of the post of Hindi teacher.
And lordships,
Okay.
only my
What is IA?
IA, my lord, there is a prayer portion, there is some wrongly mentioned, my lord, that with effect from 97, it should be full opposite, vice versa, my lord. So I've this for correction of my data, but the prayer, my lord.
It would be the amendment. It would
By
amount to
hand also,
amendment.
by hand also permitted, then I'll do it, my lord.
Huh?
By hand also, I may be permitted, my lord. I've filed an affidavit.
Okay. IA, huh? Heard Mr. J. Learned Counsel for the petition, and also heard. Any objection? No.
No, your lordship.
Learned Counsel for the. Right, State Council.
Yes, your lordship. Secondary department, your lordship.
Standing Council, Secondary Education Department. Then indicate the applicant, huh? There for Learned Senior Council assisted by for applicant petitioner and so Learned Standing Council for opposite party respondent. Next, by filing this application, the petitioner has sought for a correction in the prayer person only,
Prayer portion, lord.
prayer person.
Prayer portion, page 16, my lord, lordship may say seniority. 1497 instead of, it should be opposite, my lord. 8494 and I have to correct it only, that is 1497 should be 8494.
Not for correction, for rectification of the prayer person, huh? Mr. It is submitted that inadvertently, in place of what? 10,
1497 should be 8494.
in place of 0804, 1994. The in place of 0104, 97 has been inserted. Mr. The having considered that the petitioner has inadvertently mentioned 0804, 19, no, 0104, 1997 in place of 0804, 19. And therefore, rectification is not been objected to by Learned Standing Council. The IA still allowed and responded.
Lordship, I'm applying for respondent 4 and
I
2.
said allowed. Most of accordingly, the petition, the Learned Council for the petitioner is correct. He may, it is allowed to correct the prayer person by correcting the 04. What is 0804, 1997? 8010.
Yes,
What is?
8494 instead of 1497, ma'am.
What is? Would you there? highest thing.
And
This petition has so and so same, huh? In view of the order passing so and so, so and so. The petitioner will find amended copy of the prayer person. During the, within 2 days.
2 days.
Yes, sir.
We'll submit it today, sir, my lord.
During the course of the day. Huh? Yes. Next one, on the prayer of Miss.
Fixed terms, Your Lordship.
Sequential and standing council. For the 3 weeks time is granted.
Well, my lord, let me do 31st, my lord, because by that time, my lord, if my seniority is not corrected and their affidavit is ready, they've gone for vetting. So, my lord, 31st of this month, my lord.
Granted 2 weeks time to file affidavit.
Obliged,
weeks.
Lordship.
Date, my lord, date, my please.
Keep the date.
My lord, let it be on, my lord, 8th, my lord. 8,
8 we have fixed communication, I think. In between, wherever it is.
Then, my lord, it will be last, my lord, before we will, let it be 8th, my lord, or 7th, my lord. 7th. Obliged. My lord, only one observation on that, the map.
Yours is of 2024.
Because, my lord, the seniority only question, otherwise I lose the post of
Your
headmaster. my lord.
colleagues will be, your colleagues may,
My, then I.
your colleagues may curse you. Which cases are in the docket since, I mean, years together. Yes.
May it please your lordship.
Yes.
So this matter ought to have been listed in the admission code. Why? Because pleadings are almost complete.
Hmm.
Last occasion matter was listed in the admission column. It did
Let's
not reach.
list the matter on so and so.
Yes.
Buildings completed.
Yes.
Yes, Your Lordship.
So can it be on 25th?
It is, what is the matter?
Matter pertains to provincialization of services. So there, where what has happened, if your lordship peruses page number 81, there both the petitioners went before the division bench. Division bench came to the, after hearing both the sides. If I may read it slowly.
Tell us.
Yes. So what has happened?
For orders.
Yes. So the court was of the view, the old act, the 2011 act would not come into force. The new act, under the new act, the direction was given to consider us.
Not Mr. So and so, learned council.
On 25th, Your
Also, Mr. So and so. It is stated at the bar that buildings are complete. Then, sir. Buildings are complete, huh? Accordingly, list the matter for admission
25th. Your Lordship.
after 2 weeks.
May I please your lordship?
Yes.
Lordship, the matter may be fixed at 2, lordship.
Why? We have
Lordship,
already
my-
fixed the matter at 2.
Lordship, my senior is on the way from Brahmaputra board, lordship. There was a meeting, lordship.
Today fixed for instruction, lordship.
At 2.
Lordship at 2.
At 2.
At 2.
In item 23, I am appearing.
Ah.
Lordship, I filed my vakalatn on the last day on 28.
What remains? Have you seen the last order?
Yes, Lordship.
Should be for dismissal.
Lordship, on that day, the earlier set of counsel did not appear. I have been engaged subsequent. They filed my vakalatn.
No, what is there? What remains there?
Lordship,
It's a recruitment process of 2000.
2013.
Yes.
Understand, Lordship. Now, Lordship, one aspect which is there, at that point of time, Lordship, we have challenged the appointments in respect of one particular candidate, respondent number 37, Sushila Ahom. We have stated that he is not an OBC candidate. He is an OBC candidate and not an ST plains candidate.
No, we find that nothing.
No, your
Are you a OBC?
Lordship,
Are you a OBC candidate?
Lordship, there are 4 persons out here, 4 petitioners. Out of them, 2 I
Have you seen your pleadings? There's nothing.
Lordship, only in respect of that.
There
Lordship,
is nothing in the
Lordship,
pleading.
at that point of time,
Just because you have not been selected, you are trying to make a mountain
No, no,
out
Lordship,
of
that
molehill.
allegation has not been denied either by the private respondents or by the finance
No, how
department.
can you? What is the determinant? Suppose you show us that if had there not been a reservation, had there been a reservation, you would have been fallen. You would have been considered.
Lordship.
There's nothing on the pleadings. It's
Lordship,
a one statement saying that there is a violation of women reservation, there is a violation of this reservation, that reservation. What is this?
Lordship,
You have to show first.
Lordship,
Had it been complied, had the reservation policy been complied with, you would have been put in.
Lordship, as per my instructions, respondent, petitioner number 4 is an official candidate, but I do not have documents as of now. Lordship will grant it some time.
No, no, no. It's
Lordship, because-
2014.
Lordship, on the last.
No, no. Why?
Lordship, this is the first time appeared.
You have to file an, you have to file an application for review of this order.
No, Lordship.
It should be listed for showing that for dismissal. You will
Lordship,
show him,
that,
you show him.
no, I have perused that, Lordship. Lordship,
Yes.
that was on the count that none of the councils had appeared. I was engaged subsequently, I have filed my vakalat, but today is the first day I am appearing. And yesterday they had sought consent that my learned senior would not be available. I know that consent memo was submitted, Lordship, therefore some time is required because they had already made a prayer that they have already requested me that they will be making a mention. So sometime may be required to properly prepare because.
What prepare? This is 2014 matter. You, the last order you have seen.
Lordship, last order I have seen, but we have been
What
engaged
birth,
subsequently.
births?
We have been engaged subsequently and today is the first time appearing, Lordship, in this matter.
When did you, when you were engaged?
On 28th of February, 2020, I filed my vakalat number.
When this order was?
That was on 20th of February, if I am not wrong.
20. You were 28.
On, Lordship, that order was on 20. I had filed my vakalat number on 28th
28th
of February.
Huh.
Lordship, and today is the first time appearing. That too, Lordship, yesterday they had said that they will be seeking adjournment. Therefore, I could not go through it in the entirety because on the ground that
There's nothing,
Learned-
2-3 pages,
Lordship, that
petition.
OBC portion, which your Lordship has very rightly pointed out, that if she is ousted, whether I can be, whether, if, do I have a right? Because if I am not an OBC, I cannot challenge that. As per my instructions, petitioner number 4 is an OBC candidate. I will just obtain the appropriate instructions and your Lordship may take it up. A week's time, Lordship, that is what I am praying because.
Although this court has directed the list, directed to list the matter on, directed to list, directed to list the matter under the column with the remarks for dismissal. Come on, Mr.
A. Chakraborty.
A.
Chakraborty.
Chakraborty, Learned Counsel, that you just mentioned you on 20/02/2025. Sir L. Chakraborty, Learned Counsel for the petitioner. Learned Counsel entered appearance on the petitioner, submits that he has been engaged by the petitioner on 28/02/2025. Therefore, praise that matter may be listed after a week. Well, taking it after a week,
Lordship.
Mr. Swainso, counsel, appearing for Mr.
Atijan,
Tejaman, counsel for Public
representing
Service
APSC.
Commission, Assam.
Yes.
Assam Public Service Commission. Also prayed that his senior has some personal difficulty today. Therefore, thanks for listing of the matter after.
Much obliged.
Next, considering that the petition, Mr. Swain Chakraborty, Learned Counsel has been recently engaged. Prayer of the Learned Counsel, the prayer of the Learned Counsel, prayers of the Learned Counsel, accepted, list the lecture. After a week.
Obliged, Lordship.
You go through, there's nothing.
Lordship.
In the pleading.
Lordship, I will just. I will check.
Lordship, my senior is in leg at court number 14.
So what is to be done?
Can it be heard next week, Lordship?
Huh?
Next week? Tuesday.
You cannot fix all the cases in a day. Who is your senior?
Yes, Kanak Sharma.
Huh?
Yes, sir.
K. Sharma. Mr. So-and-so, learned counsel for the petition. Submits that his senior Mr. K. Sharma is engaged in another court. Therefore, President, refer me to Mr. 2 weeks. Whereas the law. This is the method of 2 weeks. Mr. However, considering the matter is pending since 2004, no further resolution in the next one.
Malad, in this case, before my next news statement, Malad, I am seeking a little accommodation today, Malad. Mr. K. Gogoi will argue in this matter, Malad, he has some personal difficulty today, Malad. In fact,
Who is arguing?
K. Gogoi, Malad. In fact, I informed.
What happened to him?
Malad, he is there, Malad, but he could not prepare already, Malad, some parted matters are there. Yes. Yes, Malad,
Otherwise, my lord, I normally don't object. But here is a case, my lord. A person, highly qualified person, MSc, PhD from IIT, and he has been without a job. And this issue is
Only later, we have seen some people become sadhu, who is a IIT graduate.
and he has been
Not all the IIT graduate and engineers are.
that is true. And highly qualified man,
Yes.
highly decorated man, and the ground on which we have the issue involved is squarely covered. Very short matter. I normally don't object.
I have
Looking at the plight of the person, my lord, I myself feel sorry.
gone through.
Point is squarely covered.
But then your appointment is on the follow of the honorable governor.
So, our appointment under Guwahati University. I am not on that. That issue is gone now. Guwahati University aspect is gone.
Ah.
I have now, I am without a job because Jorhat is not taking me back. That lien, the law is very settled. A lien cannot be terminated unless a person acquires a lien in another permanent post. Here,
Why these two writ petitions?
because one is, my lord, once after a series of litigation, my claim in Guwahati University was rejected by this honorable court, and it matter went all the way up to the Supreme Court.
Ah.
But my right against the post in Jorhat, that continues. In the other case, say, other writ petition, my lord, we are saying that I need to be taken back. I went and submitted my joining report. They are not taking
Jorhat.
Jorhat.
No, that's what I'm saying. What is why these two writ petitions?
One is my claim for Jorhat. Other one, they have terminated issued an order of termination. That is under challenge in the other.
Okay. So when?
Let it be in that case, my lord, let it be next Tuesday.
Tuesday. This court is fixing, every day fixing the matters after 1 week, after 2 days.
Here, my lord, as I said, looking at the plight of the person, he's all almost on the streets.
Yes.
Last 3 months without salary, without a job. Last 3 years.
Mr.
25.
I Chaudhary, learned senior counsel, assisted by. Learned counsel.
27.
Mr. A. Das,
27.
S. Das, learned counsel, submits, standing counsel
Yes,
for
Malad, higher education department.
higher education.
Here in this case, K. Gogoi will argue.
Submits that. In this matter, Mr. K. Gogoi, learned standing counsel is appearing. However, he has some personal difficulty, therefore, press for listing of the matter. After a week, yes, please, has agreed to bear a learned counsel, prayer is allowed. Has agreed to be learned counsel today. A learned counsel for the part, list this matter on 27. I think 27 also we have so many matters. We'll see.
Will not take much time.
Seniority wise, we'll see. The fixed matter will go by seniority.
Yes, fine.
Yes.
Much obliged.
Obliged.
Yes.
Actually, my lord, matter pertains to my lord, periphery of penalty.
Yes.
Actually, my lord, matter pertains to parity of penalty. All together, there are 8 persons, my lord, and the petitioners were treated differently out of the same inquiry, my lord. Petitioner was removed from service, whether the other persons, some were given, my lord, 2 or 3 persons were given compulsory retirement, although they have only 2-3 years left, and other persons were reinstated inside.
Yes.
On the last occasion, my lord, this court has directed the respondents to produce the relevant records of the case, my lord. Now, I don't know.
Lordship, records are available, Lordship, as per the office noted, Lordship, our office note, Lordship. Kindly adjourn the matter today, Lordship, and fix the matter on Monday, Lordship. Next
Available.
Monday, Lordship. I'm not
Records
going
are
to the
available.
records, Lordship.
Huh?
I'm not going to the records, Lordship. That's why, Lordship.
You have received the record.
Lordship, as per our letter, Lordship, the records are available, Lordship.
Where?
In the office, in our office, Lordship. That's why, Lordship, today,
Records have to be placed before.
Lordship,
and, used
kindly
before
adjourn the matter
records,
today, Lordship, in
not
the
in
interest
that
of justice,
chamber.
Lordship.
Not
I am
only
not
in
going through the record, Lordship. That's why, Lordship. On Monday, Lordship. As a part heard, Lordship.
Not possible.
My lord,
Oh,
then
I
on-
have not heard at all. How can?
No,
you-
Lordship, on Monday, Lordship.
My lord, then on 27, lordship, on hearing them,
Lordship, I have no
person
objection, Lordship.
removed from service,
I have no objection, Lordship.
2018 matter. my lord.
After 27. Because it would not be possible.
Then
Because
lord,
we have fixed so many matters.
Yes.
Since last 2-3 weeks, 2 weeks.
actually, my lord, matter.
Every case is urgent. Heard Mr. So-and-so, learn counsel for the police. M. Chanda, huh? M. Chanda. Totally. M. Chanda.
My lord, fixed date may be given. Yes, Chaudhary.
Let's show the learn counsel for the police. Next para, Mr.
A. Chakraborty.
S.
A. Chakraborty.
A. Chakraborty, learn counsel for the, learn spending counsel.
Lordship. GA Assam, Lordship.
Learned
Senior Government Assam.
government advocate. Government council submits them. Although he has received the records. No, submits the record has been received. However, he could not go through the study. Therefore, the matter may be listed after 10 days. They are not being objected to the land council. List this matter after 10 days.
My lord, any fixed date, my lord. 1st April is
10 days
possible,
on.
my lord.
The 1st April is also not possible.
Tuesday.
So many matters.
Then, my lord,
Then,
huh?
4th April. 4th April. 4th April.
4th April,
4th
Friday.
Friday.
Third
Then 8 April. 8 April. 8 April. 8
Make
April.
it third. Third.
Third Tuesday, yes, sir. April.
May I please?
Yes.
Lordship, this is a case where the trained graduate teachers were given once the pay scale of trained graduate teachers, and then their pay scale was reduced. Lordship, what happened in this case is that, your Lordship, petitioners are the graduate teachers working in the middle school, now upper primary, which falls under the commissioner and secretary to the government of Assam. Shall I?
Yes, are you ready?
Lordship, matter pertains to education department, Lordship, although we have already filed our affidavit, Lordship.
So who is education department?
They are required to.
Which education for, which for education?
Lordship, pertinently, Lordship, one notification has been issued by the government on this particular issue, Lordship, and this is very recent, Lordship.
Ah.
So I will definitely ask the council appearing for the education department, Lordship, to place their movement before this honorable court on the next date. Lordship.
What is it? What does it say?
Their claim has been rejected. It has been clarified.
Claim has been rejected.
Lordship, in fact, the petitioners are graduate, but they are working in an intermediate post. In the ROP 2017, it was recommended that graduate teachers will get the grade pay of 8,700, whereas intermediate teachers will get the grade pay of 6,800. So some of the teachers, Lordship, taking the benefit of some, as the matter was some kind of cloudy, Lordship, got the benefit of 8,700. So in the, but in the affidavit filed by the finance department, it has been clarified that it has been recommended only for those graduates wherein the qualification is graduate. Or intermediate,
This code has also.
probably your lordship has
First and-
decided, yes.
First and.
But
other.
in case
I
of
don't- I don't remember
intermediate,
Which way?
yes. But in case of
Yeah.
intermediate teachers, lordship, that graduate
Have you been
qualification
taken
is
to
not.
appeal?
required.
Lordship, the thing
Let us
is,
see what is that.
yes, I don't want forward.
This is,
No. This is a case, similar kind of case. There was a, in 2018, a case was decided, umbrella case, which contained all the cases of similar nature. Whereby the,
no, what I'm saying is this code has also disposed of some cases.
Yes, Lord.
Relevant,
I'm-
may
I'm-
not be
I'm
exactly relevant, I mean,
On
similar.
the same issue. Lord.
However, Lordship, when we were put this question whether we are graduate or not, we had placed our certificates that we are graduate.
No,
And above
having
the-
graduation is not the issue. The criteria required for the post is the issue, lordship. For an intermediate teacher, lordship, graduate qualification is not required. And that is why they were not recommended to get the grade pay of 8,700.
Lordship, for that, Lordship, I would like to take you to annexure number 1 and 2 and 3, your Lordship, whereby it is.
No, he said sudden notification has been issued. Let them bring on record.
Yes. Lordship
And
may
you
not.
find out,
Lord-
I mean, maybe I really don't remember. I have considered, this code has also. disposed
I
of
also
some
remember Lordship has passed
But
some.
I don't
order.
know whether in your favor or against or whatever. I mean, not exactly similar, but then somewhat related to this graduate and undergraduate scale of pay, all those things, right? You try to find out that also.
Lordship will take up this matter then after the verification, Lord. Any day.
And.
Are you in the job? Still in the job?
Some of us, a lot of people are there, some of us are
They are working.
retired.
They are
You are
working.
working, no?
Some of us are
You
retired.
are getting the
and
pay.
Some of us are retired and some of us are still working.
Okay.
Those who are working.
So
yeah.
we'll let them bring on record this notification. We'll direct them to file, bring on record.
If-
Yes, but that notification pertains to the education department.
Who
That
is
is,
the education?
Lordship, I will definitely inform them. Lordship, elementary education.
If only they can file it via affidavit, Lordship, I will also get a
That's
copy
what I'm saying.
to see.
We'll,
Lordship may,
bring on record.
Lordship may simply say the updated status on this matter, Lordship, of the government may be placed on the next date, Lord.
Maybe via
It will
affidavit,
automatically-
your
Lordship
Lordship,
may
so
not-
that I can also get a copy of the same, your Lordship.
It will be
That's what
given.
I'm
Lord.
saying. If they produce, we'll never, we'll not be behind your back.
Yes, Lordship. Thank you.
Our MS so and so,
thank you.
counsel for the petition.
He does, Lordship.
Mr. Pinayak,
I'm appearing for finance department.
Standing Council Finance Department. Submits that. The, on the similar issue,
So, I will-
about the state government has issued notifications. No. Submits that the state government has issued notifications on the related issue,
Clarifying the related issue.
clarifying the related issue. Obtained in the. Since none represent on behalf of the
Education department.
Education Department. Come on. Mr. Nayak is requested to inform the, apprise the Learning Standing Council for Education Department to bring on record the notifications and the present status relates to the present issue.
Can I be
On the next, by next. The Learning Standing Council for Education Department. Then there are education in so many people, I would say.
Elementary.
Elementary, yes, elementary. You add elementary education. May bring on record the above notification by your affidavit. As agreed to by Learning Council, will list this matter after.
Can we fix by a date
After.
Any date,
17,
after view any date?
after 20. After the ensuing
Is there
Bihu
Patla?
Bihu holidays. You hold this. Yes, sir.
Yes,
What
my
is
lord.
this?
My lord, in this matter, my lord, matter is relating to my lord, they want to make recovery, my lord, from my death come gratuity benefit, my lord, in respect of overstay period of service from my lord 18/1/1956 to 1/3/1957. I discharged my duty in that period. They said you are not entitled for that period because you are overstay in service. So they want to recover this salary, my lord. We are coming to the, my lord, facts of the case, my lord. What happened, my lord? Petitioner, the ideal date of retirement, my lord, was actual date of retirement was 18/1/2009, 18/1/1956. Actual date of birth, my lord. His actual date of birth is 18/1/1956. And in graduation list, they have wrongly recorded as 1/3/1956. My date of retirement ideal is 31/1/2016. But I retired from my service 28/2/2017, my lord, from my post, my lord. This is excess period of 13 months, my lord. In that excess period of 13 months, my lord, they want to recover 7,12,342, my lord. Lordship,
13 months.
13 months, my lord. Lordship, before that, my lord, before my retirement, I informed to the authority that this is my date of birth. You kindly discharge these things and you have to take a decision. But no one has come, my lord, to reliever of the petitioner. So petitioner is working in there, my lord, for 13 months.
Your date of birth?
Actual date of birth, my lord, 18/1/1956.
1956.
Yes, my lord.
Yes. So
And in service book, it was recorded as 18/1/1956. Huh? No dispute, my lord. That is not
service book?
Service book of the petitioner, my lord. I have annexed in here. 18/1/1956 mentioned. In gradation list, there is a mention on their part, my lord, and it was shown as 1/3/1957, petitioner date of birth.
Graduation list?
Yes, my lord. 1/3/1956. I don't know whether they are actually rely on graduation list or other. I don't know. I from the affidavit, I am submitting these things.
01/03/1956. Two more.
1957.
Huh?
The wrongly recorded 1957.
One more year.
Yes, my lord.
12 months.
13 months.
13 months.
Yes, my lord. I discharged my duty, my lord.
As per this.
Yes, my lord.
As per this.
Yes, my lord.
Knowing full well that your date of birth is actual date of birth is 18/0/1956.
Yes, my lord.
And then
Because
in service book, it is recorded correctly.
correctly.
1956.
Yes, my lord.
So knowing fully you have served.
How my humble submission before your lordship is something different, my lord.
See.
Before that, your lordship kindly go to the letter, my lord. I go one by one, my lord, and thereafter I shall come, my lord.
What do you want? They want to recover from the excess
Yes, my lord. The overstay period.
overstay period.
Yes, my lord.
What is the amount?
Amount is 7,12,342. They have abstracted my service, my lord. Now they want to, my
What
lord,
is the impugn order?
impugn order, your lordship will find page, my lord, 49.
59.
They for page 48, my lord. I have also, my lord, submitted admit card. Everything is I submitted, my lord.
Annexure?
Annexure 13.
Yes. Where is Dilip Kumar Patel?
Where Dilip Kumar Paras, who was working as a block development officer, after careful admit certificate issued by Board of Secondary Education, the date of return officer was 13/1/2026, as per OM issued by the finance department and the officer overstayed 31/26 to 28/26. Whereas the department decided to recover the done amount overstay period, the CRG officer as per standing order so and so 90 issued by the person. Accordingly, the amount done overstay period Dilip Kumar Pathak as a block loader is recovered from the CRG of the officers. And thereafter, my lord, a letter has been wrote. There's an interim order has been passed, my lord. Now the money has been kept in treasury, my lord.
Yes,
Yes, next page.
how you justify? your
I shall justify, my
overstay?
lord. Lordship, kindly bear it 2-3 minutes. I shall try to justify your lordship.
You're just saying
Yes,
justify.
yes, sir. Yes, my lord.
How many, what
Yes,
is,
my lord.
what is the grounds?
Yes, my lord. What is the law about that? And what is my lord
No, no,
happened?
You just show
Yes.
us.
Yes,
you
my lord.
just,
Yes.
Submit.
Yes.
What are your grounds? How you justify this?
Yes, my lord. I shall justify, my lord. Your lordship, kindly come to the letter dated, my lord, 2/1/2016.
Huh?
Annexer 6 series. Page 36.
36.
Yes, ma'am.
Yes.
Before my retirement, I informed to the authority, my lord. I have a lordship got it, my lord. I have inform you that as per SLC admit card, my date of birth was 18 January 1956. But till then, I have not asked serve retirement, which from departmental authority. Because if a person goes to the retirement, they should be informed. Okay, you are going to retirement so and so then. So and so, you are going retirement superintendent. I cannot leave the post like that, my lord. The post I am holding as a my lord video, I shall send it where I shall give the post by. Where I shall give the service. Then this is for your kind information and necessary action as an early date. Photocopy of the HSLC admit card.
Okay. Then
Next page, your lordship come. Again, 25/1/2016.
Hmm.
I wrote a letter, my lord. Have a lordship got it? To the authority, my lord. Respectfully, I beg to state that I am, as to my HSA admit card to see my
Okay,
date
it's
of
okay.
retirement,
next, it's okay. Same thing.
a copy see actual date of retirement, so that I may not be
Same
victim.
thing, it's okay. Proceed. Next.
Yes, my lord. That is the letter. They never denied it, my lord. I informed to the authority, and thereafter, ultimately, they served the letter, my lord. Your lordship, kindly come, my lord. On 47. And before that, and one letter is important, my lord. Annexer 9 series. I have given, my lord, submission of service book of Dilip Kumar Pathak, video season, page 43. With reference to the subject cited above, I am directed to furnish original service book, other necessary document of Sri Dilip Kumar Pathak, who was recently promoted to the post of block development officer, government notification number so and so for taking necessary action for your necessary here. And they said there is a mistake on their department. Affidavit of the respondent number 1 has categorically stated there is a inadvertent mistake of the department. That was, I was allowed to work for, my lord, 13 months, my lord. I will come later on, my lord. Then, my lord, 8 February 2017, my lord.
Who was recently promoted to post of block for taking necessary action. We have been given to who?
My lord.
Accountant General. Service book was there.
Yes, my lord. Everything is there in the office, my lord.
Yes, then.
They are not issued money delivered to me, my lord. How can ultimately they have issued on 8 January 2017, my lord. Page 46.
Yes.
I am directed to inform you that under the mention block number, you are superintendent from service on 28/2/2017. They himself, he refixes the date of return 28/2/2017. This is not my letter, this is their letter. Dilip Kumar Mathur, Sijori Kabar, you are therefore requested. Accordingly, my lord, I was released from my post, my lord. Then, my lord, they are asking for salary on statement and other. I want to go to the, my lord, affidavit. They himself stated, my lord, and they have abstracted my service. Law of the land is that if they abstracted the service, if it is not fault of the petitioner, my lord, they have to pay the salary. Article 16, doctrine of beggars, my lord. If you abstract the salary, you have to pay the salary. I'm not asking any excess pay. Overstay period, I was working, my lord, that is my salary.
It's not simply extracting the work service.
Yes.
You are also well aware that you will be your date of birth, which is entered in the service book. Of course, you have written a letter. You have intimated.
Yes, my lord.
It depends.
Yes.
Even if after the intimation, if they allow you to continue, then you may have.
Yes, my lord.
Otherwise,
May I come, my lord? Your lordship kindly allow me, my lord, 2 minutes at time.
No, it's been 15 minutes. Why only 2 minutes?
No, my lord, I have to produce some
Yes.
judgment.
Only relevant judgment,
Yes, my lord.
not three.
Ekdom sorry. I am relevant judgment, my lord.
How much? How many judgment? How many judgment?
7, 8 judgment.
No.
No, my lord, I want to.
No.
One
No.
judgment.
We're not looking into it. It's all unnecessary. Only two.
Yes, my lord.
Only two
I
judgments.
want to, my lord, because they have argued one
Because
point.
we find that
Yes.
after going to all the judgment, sir,
Yes.
spending 1 week, we find that no judgment is relevant, or the only few or only 1 or 2 judgments nearly relevant. So let us not go into all these things.
Lordship kindly allow me.
To the point,
Yes, my lord.
at best,
Yes, my lord.
1, 2,
3, my lord.
up
Three.
to 3. Not,
Three is-
not
three is
more
important,
than
my lord.
nothing.
How
Same,
can-
same principle of the law is same.
No, my lord. And
You
another
cannot
thing.
have a tree. How many, you are relying on how many principles?
Am I
One principle you are relying. How many principles of law?
their second principle is that, my lord, one letter. I have.
No. What, suppose we're on a judgment.
Yes.
How many principles of law you are relying on in a
And
one
principle
case?
Of law is one.
At
law,
best one,
one, my lord.
for that one will be enough. If
Enough?
you are relying 3, 4 principles of law, then on that, in that context, you may, if it is 3, another 2. All right?
Yes, my lord. Another point is there, my lord. I will come, my lord. Lordship kindly allow me to submit that, my lord. Every law has been discussed, my lord, here. Para 3, my lord. Puspa Mountain. Puspa Mountain.
At the date of birth,
At the date of birth of the petitioner considered 1/10/1949, petitioner would have superannuated from service 39 days. However, when mistake was detected by the petitioner on or about 27/1/2012, while she was serving as a headmistress of the concerned school, the petitioner also visited the BEO Northeastern Jorhat and informed about the anomalies regarding her date of birth. What I have
has to
done.
continue for some
Uh,
days. till
Petitioner
some
verbal
occasion
act continue the some more the see
Yes,
some.
what is the law laid out?
Yes, my lord. It has also say to me, my lord, you continue verbally, they have stated. I have stated in my petition note, verbally allowed to continue my service because without reliever, my lord, they cannot do, my lord.
When not-
In paragraph 10 of the report, they make a categorical statement. She has not withheld the actual date of birth. I never withheld the actual date of birth. And on the other hand, when the petitioner is deputed to undergo basic training, she has produced original matriculation certificate. Everything I produced. Again, when the service of the petitioner confirmed 1989, installation increment granted the petitioner. The averment made in para 10 in the above circumstances cannot be concluded. The petitioner deliberately
Traffic
mistaken. Hello?
Traffic must be. Next.
There should be last line, you will check last paragraph, man. If you allow me, last paragraph. Yes,
What
ma'am.
is the traffic mercy and all these things? What
Ne-
effects of we have to apply? why all the cases has to be
In the-
clearly resemblance facts you give? This is a case where he was or she was allowed to continue till the
I was
also-
also allowed to continue. I stated in my
No,
petition.
you may have said, what is the document?
My petition, I have stated, they also said verbally.
They have
Yes,
said,
yes,
no,
my
no,
lord,
they
verbally
have
said.
said that you have been allowed.
No, my lord, verbally allowed to continue me.
The principle of law
Yes,
is
ma'am.
to the explain whether there is any fault on your fault.
Yes,
fault,
my lord.
Whether there is any fault on your part,
Yes, my lord.
that will consider, that's all.
And another thing is, my lord, I want to show, my lord, that
Undisputedly, your correct date is 1356. You have been allowed to continue
Yes, ma'am.
another 13 months.
Yes, ma'am.
Whatever may be the reason, what would be the reason, whether it's a fault of the department or your fault, we'll have to decide. We'll see on the basis of the record, that's all.
yes, my lord, your lordship, kindly another.
If there is no fault, despite your due diligence,
Yes, my lord.
it cannot be recovered. If
Yes.
there is something which can be
Yes, correct,
attributable
correct,
to you,
correct. That is the point, my lord.
even if in a way contributory,
Yes,
right?
Yes, ma'am.
In a way, even if it's contributory, you may be
My lord,
liable.
my humble subject contributory means, my lord,
So how many judgment? This is
only
what,
three judgment, I realize Supreme Court judgment also said. One point,
this is of Pushpa Mahanta.
yes, my lord.
Pushpa Mahanta, then,
And then one of the SK Medina, Sundar judgment to get Jagadish Deka. Yes, my lord.
Huh?
Yes, my lord. And another
It's
Durgeshwar Datta.
it's already there. Yogesh Dekha,
Yes,
Durgeshwar Datta,
yes, my lord.
keep it yourself. It's okay.
Yes, my lord.
Anything you want to say?
I want
Anything
to,
more?
my humble submission
Very
because,
simple.
yes,
Why you should
my
unnecessarily
lord.
waste time?
my humble submission,
Why you
one,
should waste time of your precious time?
no, my lord, I am a my lord Deka lawyer. Dear my lord. My humble submission before your lordship is that, my lord, that they are abstracted my service, my lord. And there is a one judgment of our division bench of our High Court. Suppose I was illegally working in the department. As because they are abstracted my service, I am entitled for this salary, my lord. That is the last judgment I have given. Last slide. It is a matterless that, my lord.
I told you,
Yes,
not more than 3.
yes, my lord. Sorry.
Then you take back the other 2.
That is my humble submission before your lordship. my
That's
lord.
all.
Yes, my lord. If they
So why
say-
you have made your statement that you have been verbally allowed to
Yes, my
continue? Despite your
Yes, my lord.
information given to that your date of birth is this.
Yes, my lord.
Just give me the statement,
Yes, my lord.
the apartment which you have made, where you have made.
Professor accepted the my appearance and afterwards. That of recorded none in responsible and English on the superman that become expected. This was the discovery examiner staff. They were retaining door, where is full of regarding excel data bar. Yes, my lord. Page 66.
No, your statement.
Yes, my lord. Page 66 of my reply. Have you lordship got it? There is a continuous page, page 66.
Which line?
Yes, my lord. Pass এক দুই তিনি চারি পাঁচ ছয় সাত The respondent admitted fact that page 50 affidavit in a position 5. And the respondent number that no retirement notice was served to the department, though the department respondent authority regarding the concerned Excel data, the department further says that he was allowed to continue his service verbally by the respondent authority beyond his Excel date of retirement, for which he had rendered service to the additional for 13 months. Have you also got it? May I page 66, madam? Because of mistake or fall on the respondent authority as the neither take any step to correct the date of birth by the deponent nor send any handover video, it deny court. Sorry, my lord, that was the deponent further states that the respondent authority admitted the fact. Page 5, paragraph 5, page with the affidavit filed by the respondent, no return notice was served to the deponent regarding his retirement.
though the deponent intimating the respondent authority regarding the correction of his actual date of retire on 31/2016, the deponent further stated that he was allowed to continue his service verbally by the respondent authority beyond his actual date of retirement, for which he had rendered service for the period of 13 months. Many places, have a look at it. Affidavit in reply, I file in respondent number 1. Yes, yes.
This is your affidavit.
This is my reply. That I say.
Affidavit in reply.
Yes, my lord. Page 67, looks you got it.
Page 81.
Fine.
There is always a difference in pagination of the court record and the.
Yes.
lawyers.
66. 66. 66.
Not in the writ petition, by way of affidavit.
Yes,
The reply.
Yes, fine. In. In their affidavit, my lord, by respondent number 1, they have stated para 4, my lord, last line, page 54. Affidavit of respondent number 1, my lord, last line of para 4, just before para 5, my lord. 54. Last line, as such, it appeared that mistake of in wrong date of birth lead to wrong date of retirement, which is inadvertent human error. They have admitted, my lord, there in that is the mistake.
5. Which para?
Para page 54, just above para 4, para 5. Just above para 5.
Paragraph.
Yes, my lord. Just above paragraph 5.
No, this is by whom? Affidavit offense filed on behalf of respondent number 7 and 8.
1. Because my appointing authority is the respondent number 1. Inner page to 3, no? Inner page is 3, my lord.
Mistake in entry of wrong date of birth leads to wrong date of retirement, which was inadvertent human error.
As such, repair the mistake for entry. That is,
It's a recovery, otherwise you are getting everything.
I'm getting the recovery, only recovery. I'm getting everything.
Yes.
Your lordship, this so far as date of birth is concerned, there is no dispute, your lordship, because it is rightly entered in the service book. And all along it was in his knowledge what is his actual date of birth. It is not the case that there are wrong entry in the service book or 2 admit cards set bearing 2 different date of birth has been submitted by the petitioner. That is not the case, your lordship. All along he knows that what is his date of birth and when he is going to retire. That is his admitted case in the repetition. Now, your lordship, while he was in service, a gradation list was published. Process is the first the draft is published, and where a wrong entry is made against his date of birth. And draft list was circulated among all the employees. If there is any objection or correction to be made, they can communicate to the concerned authority. He kept mum, he kept silent. He kept silent. Your lordship, kindly see my affidavit, page number 54, just my learned senior has indicated, your lordship. May I read, your lordship? page 54, the first paragraph. It starts from 53. It starts from 53. also. It may be mentioned that the final gradation
68,
54, you'll see.
68 here
68 in his affidavit.
in the court's record. Para 4. Paragraph 4.
Paragraph 4, affidavit filed by the respondent number 1.
Yes, page 50. Yes. Yes, maybe it's earlier it was 53, now it's 68.
68, I've shown you. Lordship.
No, no, anyway, which para?
Paragraph 4, Your Lordship.
Yes.
It may be mentioned that the final gradation list as mentioned in the petition was published on 14/12/2015 by notification number such and such only after publication of the draft gradation list. Copy of the draft gradation list was circulated to all the concerned inviting objection, if any, regarding the draft gradation list, since no objection was raised by the petitioner during the stipulated period. Hence, the gradation list was finalized and published on 14/12/2015. Where the date of birth of the petitioner was shown as 1/3/1957 instead of 18/1/1956. As such, it appears that the mistake in entry of wrong date of birth leads to wrong date of retirement, which was inadvertent human error. We admit that there is,
You are not blaming him.
but facts remains, he was silent, despite knowing it, that his actual date of birth. It is not that he is also confused. No, he knows it. He knows it. Now, Your Lordship, kindly see what the law, what is the settled law, Your Lordship. Supreme Court is very much clear, Your Lordship. The facts is before Your Lordship. He is relying upon two representation from his part. We are not admitting it, Your Lordship. We are not admitting it.
My lord, affidavit silent, my lord. Nothing has been said.
Your Lordship, kindly see paragraph number 5 of my affidavit, Your Lordship.
Affidavit is silent, my lord.
Your deponent does not admit any statement made therein which are contrary to records or inconsistent. So we are denying it. We are not admitting it. We are denying it.
And I have given that, my lord, a postal stamp also, my lord.
Now, Your Lordship, what is law speaks, Your Lordship? What is the law, Your Lordship? I will rely on two Supreme Court decision only, Your Lordship. Short decision, very short. Your Lordship. Yes, yes. Yes.
Yes.
Well, it's a very short decision. Your Lordship, here is a similar matter, Your Lordship. When the action was taken to recover the amount paid to him for the period beyond the date he was to retire, then he hesitated, Your Lordship. Now, Your Lordship, paragraph number 3 of my judgment, Your Lordship, 1997, 9 SCC, page 239, Your Lordship. May I read, Your Lordship? Para, Your Lordship, 3, Your Lordship. Similar situation, Your Lordship. The learned counsel for the petitioner contends that since the petitioner has worked during the period, he is entitled to the payment of the pay and allowances from 1/6 so-and-so to so-and-so. That he is also entitled to the payment of provisional pension, death term, retirement, gratuity and leave encashment, communication of pension amount, GPF money and amount deposited under CGSC and such and such, such and such. We are aghast to notice the boldness with which it is claimed that he is entitled to all the benefits with effect from the above said date, when admittedly he was to retire on 31/5/1991. It would be an obvious case of absolute irresponsibility on the part of the officer concerned in establishment in the section concerned for not taking any action to have petitioner retired from service on his attaining superannuation. Similar situation. It is true that the petitioner worked during that period, but when he is not to continue to be in service as per law, he has no right to claim the salary, etc. It is not the case that he was re-employed in the public interest after attaining superannuation. Under these circumstances, we do not find any illegality in the action taken by the authorities in refusing to grant the benefit. This is the
1997.
1997.
Have you seen Rafiq Masih?
No,
Yes, my lord.
Masih will not come there.
May I submit, my lord? My
The
lord,
principle of law,
Masih will not come.
according to you.
Yes, there
He's an officer.
No, my Justice Major, there are 6-7 guidelines, my lord. Under what parameter, what will be the case? May I submit, my lord? First, graduation list, when it has come to my knowledge, my lord. That is the important, my lord. I have stated in my reply, my lord.
Okay, let him.
Sorry.
is another judgment, Your Lordship. This is in 2009 3 SCC 117, Your Lordship. Your Lordship, here, Your Lordship, the state preferred this SLP against the
What is judgment reported in?
2009
Hmm.
3 SCC 117.
Name of the party
State of Bihar and others versus Pandey Jagdishwar Prasad.
and the
Yes, Your Lordship. Your Lordship,
Para.
para 28, Your Lordship.
Yes.
Yes. Here, Your Lordship, state authority was relying on this. My earlier judgment, I have relied upon, Your Lordship.
So which is the para?
28, Your Lordship.
That's all.
May I read, Your Lordship?
It's okay.
Yes.
Yes.
Before parting with this order, we may refer to
It's
decision of.
okay.
Yes.
There has been relied in
Yes.
earlier case. Radha Kishun.
Radhakishun.
That has been relied. It's okay.
Yes, Your Lordship.
My humble submission before your lordship, what my learned friend has stated in that there are two representations. They never denied this representation, my lord. And next thing is
Sir,
important.
he has not completed.
Oh, sorry. No,
Why you are jumping on it?
Yes,
He is yet to complete. Huh?
sorry.
Yes.
Yes.
Your Lordship, may I read the
No,
judgment paragraph?
It's okay. He relied on this Radha Kishun.
Radhakishun,
That's it.
particularly on paragraph 28 only.
Anything else?
Nothing, Your Lordship, that's much my.
My submission is there. Accountant General. I also find. Or maybe they can take after.
We'll take it to continue it to.
Yes, sir.
It will be these two things.
Right, it is respondent number 7 and 8, Miller. I have filed affidavit. Wherein I have stated in my Lordship paragraph 7 of affidavit.
What is your role?
My role is only because I am the authority. Sanction and on the basis of government decision, we are only redacting because pension is issued by us, Accountant General. Ultimately, that recovery was made by us on the basis of this one Form 19 issued by the government department. Here I am coming to law point, Miller, 1 point. Here, not you get it. Not you got it, my friend. 7 and 8. Affidavit in opposition.
Yes, yes.
Here, Lordship, I'll get this one. Here about, I'm telling about 95, section 95, what it says. Pension rule. Here I am quoting also this one.
Para?
Paragraph 7. That with regard to the statement made in paragraph 5 and 6 of the writ petition, the humble deponent begs to state that from the writ petition it appears that petitioner is aware about his date of birth and date of retirement. And being a gazetted officer, he should also be aware of about the Rule 95 of Assam Service Pension Rules 1969, wherein it is categorically mentioned, if no intimation is, however, issued to the officer, this shall not in any way change his date of retirement
and shall not confer on the government servant any right to remain in the service beyond date of on which he is required to retire. Therefore, the petitioner should not have continued service for another additional year, because this is R95 clearly says that affidavit in reply was filed to my affidavit in opposition. But I have seen this regarding 95, though it is paragraphs against Faganan 8 is replied, another paragraph also there. But regarding that 95 section, he is silent because it's a law point. This is before your lordship. There is nothing to, because law clearly says the one officer doesn't have right to continue. He may not be given. He may not be given charge, or he may not be said by you are to go by this notice, you are to leave the office. Nothing to add. You are an officer, you are supposed to leave this, or you cannot continue. If somebody wants to continue, cannot. 95 clearly says. Second, my point is there. Second point, my affidavit says, when their pension papers are being sent to me by, let's say, government department will send it. There is a form where form 19 is required to be filled up. Here, this department has clearly stated that 7,12,340 is to be recovered. Now my annexure 7 page 2 Miller, or page 7 Miller, annexure 2 of my affidavit of position. Undertaking. His undertaking, lordship is seen. Here, lordship got it.
Annexure 2.
Annexure 2 of my affidavit in opposition, that is page number 7 internal, please kiman hobo jano? Kiman hobo? Mutu kiman hobo, please? Acha. Lordship got it, I think. That. Annexure 2 undertaking, your lordship got it? Yes, my lord. Shri, so and so, his name, regarded as expert, this is so and so, office of the commissioner, Jaipur 37, hereby declare that I have no objection to refund or recover the excess drawl, if any, in case of any pay and allowances, or from my original pension, discharge, gratuity, arrear pay and allowances. That is his signature, right hand side, and is then official. This is two points I am giving, my lord. As per first point is this one, as per provision of section rule 1995, he doesn't have right to continue. He would have gone because this one, that is clearly says. Second point, the department has sent form which is required to be sent to us, to clearly asks us to recover. Third point is I am telling the undertaking is given. That is my point. Now, no more beyond that, I cannot go by. Affidavit is very short, but he has not contradicted to my section 95 or rule 95. That is my decision. Oblige.
Rule 95 to deal with that.
No, kitab phone lo.
Answer to
Video.
He will submit something.
Your lordship, in the morning session has asked a question about the applicability of the Rafiq Masjid. Your lordship.
It's okay.
Your lordship,
We're not going to it. We just raised it. That's it.
Your lordship, the paragraph 2, 3, and 4 may kindly be seen.
It's okay.
I am supplying the copy, your lordship.
Don't place unnecessary judgment. Let us know.
Yes, sir.
I feel
One
it's
thing more
unnecessary
I would
burden.
like to indicate, your lordship. Your lordship, the petitioner was
What is this?
Rafiq Masih.
It's okay.
Paragraph 2 and 3, 2,
It's
3
all
and 4.
right. Keep it yourself.
With
you.
Lordship.
It doesn't-
One thing I'd
not
like to
required.
place, your lordship. Your lordship, the writ petitioner was the block development
We're
officer.
not going into roughing much.
Block development officer. He was a block development officer, and he was the head of that particular block. So it is of that office, your lordship. That is his responsibility. It is not there always the government has contributed to it. What has happened, your lordship? It is his responsibility.
It's okay. He may have a responsibility. Equally, you have the government also has the responsibility.
Definitely, your lordship, the is very much clear. in this one.
Lordship, I am not touching the point,
You
my
have
friend.
to release him on his retirement, attending age of superannuation. You have also not released him.
Yes, admittedly, we failed to release him, but it doesn't necessarily mean that he will hold in and continue the office, Your Lordship. Whereas it is in his knowledge, the exact date of his
At the
retirement,
time
it is
of,
in his knowledge.
at the time of his retirement, actual retirement, you have allowed him to continue for 13 years, 13 months. And then you have, your affidavit says inadvertent, human error.
No, inadvertent, it is done in the gradation list, Your Lordship. He
You are
never
not-
raised any objection.
You are not saying anything against him that it's because of his fault.
Your Lordship, paragraph 5 of my petition, my affidavit may kindly be seen.
Para 5 and para 4. Last you said it's due to human error. Whose human error?
He is himself, Lordship. Lordship, I'm only on 2 points, Lordship. Lordship, in the office of the block development officer, he was holding the post of BDO. So that is, he was the head of that office.
You are for?
I'm for the finance department. So first point is, Lordship, it was his responsibility to point out the authority that on such and such date.
He has pointed out
Never.
before retirement.
Never, Lordship. That
Second of January.
Those documents are disputed, Lordship. And secondly, Lordship, in his service book, Lordship, his date of birth is written as 18/1/1956. That date is not disputed. By following this date, Lordship, he should have retired on 31/1/2016. Lordship will kindly note this date, 31/1/2016, but he continued up to 28/2/2017.
That is also not disputed. Nobody is disputing that.
Yes, that is what I'm coming with. For this entire.
The issue is whose fault it is.
Yes, I'm coming to
Is
that
it the
point.
government or the petitioner?
That point has already been stressed, Lordship.
Yes.
I'm not even touching those points. For this entire 13 months, Lordship, he received salary. Now, if Lordship comes to the last page of the petition, Lordship, last page, Lordship, may kindly see that page, Lordship. It's a letter dated 13 June 2018.
Of what?
Of the writ petition,
Okay,
page 51.
page 51.
Yes, Lordship. Last page, Lordship, last page.
Yes.
Lordship, it's a letter by the Joint Secretary to the Government of Assam to the Joint Secretary Panchayat, Lordship. With reference to the subject cited above, I am directed to convey the sanction of the Governor of Assam to the payment of provisional pension amounting to rupees so and so only per month with the allowances as admissible in respect of Sri Dilip Kumar Pathak, retired Block Development Officer, Srirang Development Block, Bongaigaon, with effect from 1/2/2016. Lordship, if he would have retired on 31/1/2016, he would have get pension from this date. So for this period of 13 months, Lordship, he received salary, he received pension as well. Lordship, whether a person can claim double benefit in respect of the same service.
Yes, well, that point is correct, my lord. I cannot claim. Sorry, that down also.
If I am correct, Lordship, then recovery is correct.
No, I am not telling.
So Lordship will consider that point only, Lordship. He is not entitled to any double benefit.
That makes me think that you have allowed him to continue work for
Allowing or
13
not,
13 months.
Lordship, even if it is whole, it held by your Lordship that he was no.
What about his labor? of
Yes,
13
even
years?
in Lordship, that is
13
what I'm
months.
trying to impress, Lordship. Even if it is found that no misrepresentation was on the part of the petitioner and the authority allowed him to continue, even in those situations, Lordship, he cannot be allowed to receive two benefits. If he is getting salary, then you will not get pension for that period. And if you are receiving pension, then you should not claim salary for that period. That is the general principle, Lordship. Nobody is entitled to such benefit. So that is my only submission, Lordship, as he is receiving pension for the entire 13 months period. So he is not entitled salary. And if your Lordship held that we cannot recover his overpaid salary, then Lordship will give us that. Lordship?
You have sought for recovery only of the salary,
Yes, Lordship.
not the pensions which he is getting, including these 13 months.
Yes, Lordship. But that is a
How
separate issue.
his pension has been calculated,
From
including that 13 months?
Yes, Lordship. He should have retired on 31. That is why I'm stressing the date,
Yes,
Lordship.
yes.
31/1/2016, he should have originally retired. He received pension from the very next month, 1/2/2016. Whereas he continued till 2017. So that is the subtle
So
principle.
pension calculation is also for till 2016. The
Yes.
actual date of
Yes, yes.
his retirement.
Probably it was calculated on.
Whether 13
yes.
months has been included,
Yes.
excluded.
So my only submission, Lordship, he should not receive any double benefit, either receive salary or pension. That is one only, and Lordship will.
Yes.
Yes, ma'am. My humble submission before your lordship is that, first, your lordship kindly, I guess, shall give the answer of my learned friend, respondent number 1. What judgment has been shown by him? First, that is my lord. That my lord Pandey Jagadishwar Prasad, that 2009 3 SSC 117. That judgment supported me, my lord. And both these judgment has been distinguished in Puspa Mahanta case. I have given Honorable Justice Osindra Malla Judicial Burua and Honorable Justice my lord Sanjay Medi. Both the judgment has been distinguished. What my learned friend has said, that has been discussed. Actually, what happened in this judgment, my lord, may I read some paragraph, my lord, or not necessary, my lord. Para 23, 24, if your lordship read everything.
That which one? Pandey.
Yes, my lord, that Pandey Jagadishwar Prasad.
Yes.
I will got it. Paragraph 22. Without going into whether the appellant has justified from 2 years from the actual date of the deduct salary enrollment paid to the, we may say that since the respondent had worked during the period without raising any objection from the side, or the appellant had got work done by the respondent, we do not think it proper at this stage we allow the deduction from his retrial benefit. And the amount received by him as a salary after his actual date of retirement. Considering the fact that there is no allegation of mishandling which could attributed that had allowed the person to work, got work done, and paid salary. It is unfair at this stage to deduct the said amount from the salary amount. Accordingly, we are in agreement with the division bench that since the respondent was allowed to pay salary for the work of 2 years after the actual date of retirement, raising objection, no deduction could be made from the period retrial benefit of the respondent. Last part, my lord. Then, your lordship, they cannot, my lord, deduct from my retrial benefit, my lord, the salary which has been paid to me. My learned friend has said, just now my learned friend said, that thing has been said. That I cannot take the two benefits. One is pension and other is salary. The amount pension should be calculated from the date of actual retirement 2016. But I cannot take the same benefit. So from the salary, the pension part will be calculated, although from 2017, but in respect of my lord, scale and others, it should be calculated from 2016. That has been mentioned. And Puspa Mahanta judgment, that thing also mentioned, my lord. Para 28, he said, we may refer the decision of the strongly Radhakrishnan Learned Council appearing in the decision that has been read, my lord. I am read para 30. There is another aspect of the matter, although we directed the excess amount paid for 2 years to the respondent as salary cannot be recovered from the respondent.
Distinguished.
Yes, ma'am.
It's not relied on distinguished. It has been distinguished.
Your lordship.
Radhakrishnan has been distinguished.
Distinguished, yes. That is in my favor, your lordship. Your lordship, in this Jagadishwar Prasad case, your lordship, there was confusion. Because in the service book, 2 date of birth was entered. Here in the Radhakishan, there is only 1 date of birth. There was no confusion. In his case also, in the service book, only 1 date of birth which was in his knowledge also, all through. And he is holding the post of head of that particular department office, Your Lordship. Kindly see paragraph
There is a
28.
different date of birth in the
There is no confusion.
gradation list.
Gradation list is a different thing, Your Lordship. Person always retired on the basis of the date entered in the service book, not on gradation list, Your Lordship. And fall on his part, he never raised that issue before the authority at the specified time, Your Lordship.
I am raised the issue 2 times. They are not.
No. So far as gradation list is
So
concerned, he
far-
never.
Gradation-
And so far as his representation is concerned,
Sorry, my lord.
we denied it,
And
Your
both
Lordship.
the judgment, it was distinguished. And second thing is, para 5, I said verbally allowed to me.
What
as per
about
the-
rule 95?
Rule 95, nothing is said. That is why I'm asking the book. Let them show. What is the rule 95 say? Yes, so, my lord.
Yes, yes.
What rule 95
Nothing
has said?
shows, then I'll
Yes, my
show.
lord.
If he's disputing, definitely I have to show.
Yes, my lord.
Lordship,
I'm disputing.
Lordship take out.
Yes, my lord.
Lordship may take out there.
Yes, my lord.
You should not say because books, it is clearly
Yes,
written.
yes, sir, which
Wait,
is-
let me see, you have submitted. It is my duty now.
Which book?
Pension rules,
Huh?
pension law 1969, my lord. এখন দিয়ক, এখন। Pension এখন লওক। এখন দি দিয়ক, মই মাৰ্ক কৰি দিছো। Lordship may read. মই put mark. Same. না, এটা চলে যাব। নেলাগে পঢ়িব। লাষ্টতে দিছে নহয়। Lordship may take decision anyway, but my learned pencil, nothing is mentioned. Then from where I have put that words? You have given you book that time. No, then I'll show now to judge. Now we judge now. No, না আপোনাক দেখুৱালো আৰু wait for.
তুমি গাধা কৰি মোক দেখাত না।
গাড়ীৰ কথা আমাৰ কিতাপখনে দি দিলো মই। মই দিম নহয়। নালাগে দিয়ক। তেওঁ কিতাপ আনিব লাগে না। Lordship may take any view, it is up to Lordship. But our duty is to give submission. Books. That is your counsel.
হ'ব দিয়ক দাদা, ইমান কাউন্সিল নক'ব আৰু। কাৰণ মই এফালে বেয়া নকৰিব মোক। সকলো বুলি নাভাবিব দাদা, দাদা কথা নক'ব। মোকতো আপুনি দাদা কথা নক'ব, মই ক'ব হয়।
আপুনি মোক বিচাৰে কিয় বুলি কৈছে?
জাজমেণ্টটো দেখাব কৈছে আপোনাক।
চাই লওক না আপুনি কওক।
নাজানো মই জানো।
সম্পূৰ্ণ 95 টো পঢ়ক না। 95 টো ক'ব নহয়।
Basically, it says the provides the procedure.
If no,
Intimation has to
my
be given.
submission is there, no intimation.
Before 1 year, list has to be, the intimation has to be, even if.
No
there is
intimation, however,
that will
suppose
not- they'll not
here
change-
it is saying,
It will not change the date of.
here it is saying, here date
retirement.
of birth is not a question. Here the question is there, his first submission is before your Lordship when he started, to whom I'll hand over, because nobody is taking relief. That is why, if somebody is not relieving in, doesn't mean that he can continue. That is our submission. That is your submission, Lordship.
Submitted, my lord. Nothing is there, my lord.
Initially, requirement is, as you said, intimation has to be given, procedure prescribed.
If
Just wait.
suppose no intimation is given,
Ah.
he knows. Here says, suppose
Even if.
he knows,
If
he
no
knows date of
intimation is
birth.
given, that will not change the date of birth.
That
It
is
says
correct.
95.
That is the date of birth is not changed here. Here question is that he knows date of birth. His first submission was before Lordship very beginning. It was said
May-
nobody
it
has
may not
come.
change-
No officer has come. That is why I
Sir,
cannot hand
it
over
may
the
not
book.
change the date of the birth. Obviously, it
Date
cannot.
of birth is he knows.
But then
He's
your
supposed to
duty-
retire on that
the-
day. He
the
knows this.
respondent's duty is to intimate. If you rely on Rule 95.
That is my,
Yes,
here my
you have
sub,
also not done your job.
no, my submission, is-
you,
no,
by
no,
the
no, no. Here
concerned
this
authority.
intimation is saying, my lord, suppose he knows the first very submission was before his Lordship was there. when he started, that no
Sir,
opposition
you
refused to
have,
refer.
there are huge, big paragraphs. You have read 3-4 lines. You have relied on the
But
3 lines.
No,
4
that
lines.
is why, because I have to judge this term
Which is favorable. to-
substantially.
You
This
have,
other
you
portion also is
you have
applicable to
omitted
me.
to read the provision.
No,
which is
appropriate date is also
in
is
favor
there.
of the
Here
petitioner.
question is there, his date of birth, he knows, his question was very
Sir,
sufficient.
you ought to have been fair.
Very beginning, his submission was-
Entire provisions of section 95. You have
Lordship,
read, cut and pieces.
but that is, anyhow, I may be wrong, but it is not contradicted when his reply was given. You would have replied to that. His environment is not controverted, deemed to be admitted. My submission is admitted. That may be recorded, Miller. Obliged.
It's no longer a good law.
Maybe a good law, your lordship may decide.
I have contradicted, my lord, denied and.
Okay,
disputed.
that's all.
That's all. Our para 5, I have categorically
It's okay,
stated, verbally. Everything is
Heard
mentioned.
Mr. NLB Chaudhary, learned counsel for the petitioner. And also heard who is what?
And Commissioner and Secretary, your lordship, the PNRD department. I'm appearing for 1, 2, 3, 4, 5.
Additional Advocate General.
Yes, sir.
Then,
Then your lordship,
I am appealing for
no, 7 and 8. For the
Accountant General.
Ah, 7 and 8.
Accountant General.
9.
there's 6 and 9. 6 and 9. please.
6 and 9.
6 and 9.
Hearing concluded, judgment reserved.
Obliged, your lordship. Made, please, your lordship.
Yes. They're seeking, they've sought for a time, they prayed for a time.
Yes, my lord. In fact,
Where the council.
But from their side, my lord, council has given the report. This basically now is the government's decision. What I was praying for is, my lord, by setting aside this order at page 94.
94.
Lordship- Yes, lordship should remand this matter for a fresh consideration, my lord. Because they say a particular order, this one.
Twenty-second April 2021.
Yes, yes, my lord.
95, 94.
In inviting a reference to the correspondence quoted above, I am directed to say that following high school introduced higher secondary section during the year 1995 to 2005, but Assam Higher Secondary Education Council has issued feasibility report during the year 2015. The Assam Higher Secondary Education Council has also stated by the letter dated 33/21 that feasibility report was pending due to decision of the council not to issue feasibility report in respect of provincialized high school for introducing higher secondary classes thereon, as such schools are under direct control of the Director of Secondary Education. It also appears that higher secondary classes were introduced during the year 95. So there is no dispute, my lord, that we started classes before 1/1/2006 in this provincialized high school, and these higher secondary schools are running since then as venture school. In view of the visibility report issued by the Higher Secondary Education Council, together with your proposal for according permission to open first year higher secondary classes by your letter under reference, and pendency of the matter may be attended, and steps should be taken to invoke provisions of the relevant rules in force in respect of matter of permission as prayed for by the 20 number of schools as mentioned below in respect of the 20 schools. It is to be mentioned that non-government educational institution regulation is in force that the government will not bear any financial liability in future for any permission as per the existing rules. Then Milord will kindly come to the order at page number 110.
These 20 schools are the petitioners.
My lord.
20 schools are the petitioners here?
Yes, 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 all
All
the
20.
petitioners. Then please come to 110, my lord. With reference to the above, I am directed to clarify that government letter dated 22/4/21, which I read, is not a permission in respect of 20 number of schools as mentioned in the letter under reference. So this is the second order which has been challenged. Then my lord will kindly come to page number 165. Seen and peruse the order of the Honorable High Court passed in the following petition, where serving as teaching and non-teaching staff in their respective school as shown below. The Honorable High Court in its common order dated 31/8/23 passed in the aforesaid writ petition directed the petitioners are entitled to a direction to the state level scrutiny committee headed by director that the recommendation made in favor of the respective schools by the respective district scrutiny committee be taken into consideration by the state level scrutiny committee headed by director, examine the same as per the entitlement and pass a reason order thereon. On verification of the required particulars submitted by the inspector of schools of the district, it was found that district scrutiny committee did not recommend the name of the above mentioned higher secondary school where petitioners were serving as teaching and non-teaching staff in their respective school. It is found that inspector of schools of the district simply forwarded particulars of the school and as well as the staff. As per provisions of the so-and-so Act as amended under section 2H and the Assam Education Provincialization of Services of Non-Teaching Regulation Staff of Venture Educational Institution Act 2018 under section 2B respectively. District Scrutiny Committee means District Scrutiny Committee constituted for each district. Recommended names of venture education institution along with the names of the teachers and tutors whose services are considered eligible for provincialization. The petitioner schools and services of teaching and non-teaching staff could not be considered for provincialization under the aforesaid act for the reasons that government permission for higher secondary classes was not available against these schools from the competent authority in due course of time. Also, as per the provisions of the aforesaid act as amended in 2018 under section 3(1)(I), that the venture educational institution which have established and obtained the required permission, recognition, appellation, concurrence as the case may be, up to the last date of highest class required for the concerned institution from the respective competent authority or authority honored before so and so. Provided that the order of permission, recognition, affiliation, concurrence, etc. shall have to be issued honored before 1/1/2006 and any other issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of the school as the teachers, tutor, as the case may be of the institution. In view of the above facts and circumstances, the aforementioned schools and services of teaching and non-teaching staff cannot be considered for provincialization. Now, what your lordship finds basic ground which they have ascribed this, my lord, that before 1/1/2006, the requisite permissions were not given.
Yes.
Then my lord will kindly come to the last order at page 171.
Yes.
Reference to a letter under reference on the subject cited above. I have the honor to state that this office-wide letter dated 11/7/22 had furnished the report regarding provincialization of 20 number of higher secondary schools in different districts, mentioning that these 20 higher secondary schools have received government permission in the year 21, white letter dated so and so. Accordingly, white government letter dated 14/9/22 had clarified that government letter dated is not a permission in respect of 20 secondary schools. Hence, 20 number of schools cannot be considered as government permitted higher secondary school.
This is for favor of your kind information and necessary action. Now, what I find subject to what your losses may say, my lord, on 22/4/2021, permission was given. Now, my lord, from that communication, lordship has seen that higher secondary council did not give the permission for their own reasons. But there is no dispute that we were established, we started classes in from 95 and we are continuing till then. Now, my lord, if your lordship kindly comes to our affidavit in reply, it starts at page 183. If your lordship would kindly come to page 92.
192.
Yes, my lord.
Yes.
This is in respect of one of the school. It was on 19 December 2005. In inviting a reference to the subject cited above, I am directed to request you kindly to submit an inspection report for upgradation of Folimari High School into higher secondary school. The inspection report must contain the following. Now, if your lordship kindly comes to the next page. (194), similar requests were made, my lord. Then at page 196, similar requests made. Then my lord will kindly come to page 198, similar request made. Then my lord will kindly come to 199. Your letter dated 22 with reference to the subject cited above, I have the honor to submit herewith inspection report for upgradation of so-and-so into higher secondary school under so-and-so. This is for information. So these are there, my lord. If you don't act on this, why do you blame us? Technically, yes. Technically, on 1106, some of the requisite permissions were not there. But these are very much there. So, my lord, district level committee has recommended our case. Now, state level committee merely on technical ground has passed this order at 167 and 171. So, my humble submission is, my lord, we should reconsider having regard to all these attending facts and circumstances.
Admittedly, it was not recognized.
Yes.
Permitted.
Yes.
Till 1/1/2006.
No, my lord, we have started classes of
95 to 2005.
95, yes.
Yes.
And they are continuing till date. Now, if your lordship could kindly come to this communication at page 94. Yes. When I paid page 94, my lord, 22/4/21, the first para, last three sentence. It also appears that higher secondary classes were introduced during 95 to 2005 in these provincialized high school, and these higher secondary schools are running since then as venture schools. Technically, my lord, things are not there, but otherwise everything is there. So is it not the duty of the state level scrutiny committee to lift the veil and find out whether the requisite permission during the meaning of the Act of 2017 is there or not?
What is the provisions of
Yes.
recognition?
Lordship will kindly have this book, page 99. Section 3.
Yes.
At page 108.
Yes.
Subject to the provisions of Article 30 of the Constitution of India, the following categories of venture educational institutions shall be eligible for being considered for provincialization of the services of the teachers and tutors. The venture educational institutions which have been established
and had obtained required permission, recognition, affiliate contract as the case may be, required from for the concerned institution from the respective competent authority on or before 1/1/2006. Technically, yes. But my lord, what to do? In 2005 itself, the inspection report was granted which recommended. So my lord, the state level committee should have gone into these aspects. And there is one more act, my lord. If your lordship would kindly come to page number 573. Sorry, it starts at 573, yes. Assam Non-Government Educational Issue Regulation and Management Act. If your lordship would kindly come to section 6. Six one at page 579. The existing non-government educational institution shall submit application for registration of the institution before the director, furnishing the full particulars and informations, and on payment of such fee as may be prescribed relating to the institution sought to be registered, and shall also furnish the copies of the government permission or recognition, if any, previously obtained before the academic recognition, before the academic from the respective board or council, as the case may be, within 6 months from the date of commencement of the act. If your lordship will kindly come to the bottom of the page, this amendment came into being in 2018. So within 6 months, we have to intimate. Then the proviso that in case of failure of any institution to register the institution under subsection 1 of section 6 within the stipulated period, the institution shall be allowed registration on payment of fees with 50% increase of the prescribed rate, provided institution is registered within a period of 1 year from the date of coming into force of the Amendment Act. In the event of failure of any institution to register in 1 year, as stipulated above, director shall issue notice to close down the institution in a phased manner. Now, please come to section 10 of this act, my lord. Now, I would respectfully submit, if section 6 is not applicable, then section 10 will come into being. Requirement for establishment and administrative recognition of non-government educational institution. No non-government education shall be established or run, will come in the second category. To such institutions shall be no run, and no permission or administrative recognition shall be granted unless the institution fulfills the following requirement. Please come to B. For a high school, higher secondary school and senior secondary school, including composite school, the school have at least 5 bighas of land in one plot in rural area and 3 bighas of land in one plot in municipal town and committee and 1 plot of land in Guwahati. Provided non-government educational institution already granted prior permission and administrative recognition with land requirement before coming to force amendment shall be allowed to run. So, my lord, supposing even if I don't have the permission also, I should be allowed to run provided I fulfill the requirement of B.
You have all this requirement.
Yes. So therefore, what I am
It's high
submitting is,
school or
my
higher
lord,
secondary school?
yes.
It's
I
high,
am-
high school or higher secondary?
Higher secondary.
Higher secondary.
My lord, what I am respectfully submitting is this order at 167 and 171, those should be interfered with, because earlier we approached this honorable court. This coordinate bench of this honorable court directed them to consider. That consideration has gone against us. But they have not disclosed all these reasons in the rejection order. So let them take a fresh call. That is my humble submission, my lord. If your lordship could kindly come to the earlier order of this honorable court at page number 163. The limited grievance of the petition, para 4, the limited grievance of the petitioner is that under the provisions of the Assam Education Provincialization 163.
Yes.
The limited grievance of the petitioners is that under the provisions of the Assam Education Provincialization of Service and Teachers and Reorganization of Educational Institution Act 2017, there is a requirement for state level scrutiny committee headed by Director of Secondary Education to give a consideration to the recommendation made by the DLC. In our case, my lord, there is no dispute that DLC's recommendation is there from. Therefore, we are of the view that petitioners are entitled to direction to state level scrutiny committee headed by director that the recommendations made in favor of the respective schools by the respective DLCs be taken into consideration by state level scrutiny committee headed by director, examine the same as per entitlement, pass a reasoned order thereon. To facilitate the process, the respective school to submit individual application before the state level scrutiny committee headed by director, along with a certified copy of the order stating in detail the recommendation that may have been made in respect of the schools by the DLCs, and upon applications being submitted, the state level scrutiny committee headed by director shall pass a reasoned order hereon within a period of 2 months from the. So, my lord, this direction was technically complied with, but there is no reason indicated, my lord. When our schools were inspected, everything was done. Where are those, my lord? And the Higher Secondary Council themselves say it was pending with them. So is it our fault, my lord? In that view of the matter, my only submission at this stage is, my lord, let them reconsider the matter.
Wait, Your Lordship. My lord, I will kindly come to the impugn order, my lord, whereby their provincial constitution was rejected at page 165.
Page 165.
Page 165. My lord, the second paragraph, third paragraph, my lord. After the list, my lord, second paragraph. On verification of the required particulars submitted by the inspector of schools of the district, it was found that the district scrutiny committee did not recommend the name of the above mentioned higher secondary schools where the petitioners were serving as teaching and non-teaching staff in the respective schools. It is also found that the inspector of schools of the district simply forwarded the particulars of the schools as well as the staff. So the basic requirement under the 2017 Act to recommend the name of the school and teaching staff by the district scrutiny committee. In the instant case, my lord, the name of the school and the staff were not recommended by the district scrutiny committee. If it is not recommended by the district scrutiny committee, then the consideration by the state level scrutiny committee doesn't arise, my lord.
Where is the forwarding?
Sorry, my lord.
Where is the forwarding according to you?
My lord, 13, my lord, section 13.
No. You are saying that it has not been recommended, but it has.
This is the finding in the impugn order, my lord.
No, simply provided. On what basis?
That is not clear, my lord, in the simply for, because forwarding has to be done by the district scrutiny committee, not by the inspector of schools, my lord.
They said it has been recommended. Then you will have to show that since you have said that it has been simply provided.
Yes, my lord, forwarded but not recommended by the forwarding has to be done by the recommendation has to be done by the district scrutiny committee. Then only for
where it is.
My lord, in fact, in our affidavit, I don't find it, my lord, but in the impugn order, it is there, my lord. It is not recommended by the district.
It's okay. It's impugn. It is put to challenge.
Yes, my lord, that is why I'm
That's
saying.
a challenge.
That is why I'm saying if it is not recommended by the district scrutiny committee, it is the finding of the director of secondary education. If it is not recommended by the district scrutiny committee, then question of consideration by the state level scrutiny committee doesn't arise.
No, that is their finding which is under challenge. It's under challenge. Now, you'd like to see if you have,
That I can produce, my lord, whether
since you have said that this has been simply forwarded, not
yes,
recommended.
yes, that
What
I
is
can
the
produce, my lord.
documents?
That I can produce, my lord.
My lord, will kindly come to page 102, my lord.
102.
Yes. Minutes of the district level scrutiny committee. At the very outset, the chairman welcomed the members present in the meeting and requested the inspector of school to place the record documents for provincialization of so-and-so higher secondary school. So-and-so, as per the Act of 2017, as amended in 2018 by DSC's letter dated so-and-so. Accordingly, Inspector of Schools, GDC has places the record documents of the school before the house. After threadbare discussion, the following resolution has unanimously been adopted. On verification, it seems that 4 number of schools have got permission for class 11 by dated so-and-so, and accordingly, the house has forwarded for provincialization of higher secondary school as well as teaching and non-teaching staff as per Assam Educational Provincial Service of Teachers Reorganization of Educational Institution Act 2017 as amended. The meeting ended with vote of thanks. So, my lord, there are records are there. How my learned friend is saying that it is not there. That is the extent of non-application of mine, my lord.
And
All that I am saying is let them re-verify and pass a reasoned order. I am not asking for any relief straight away from this honorable court.
And in any case, my lord, as on today, my lord, they do not have the permission, my lord. Since they do not have the permission under section 3(1), my lord, they are not eligible for provincialization. Let me come to section 3(1). Section 3(1), my lord.
Just wait.
Yes, ma'am.
Yes.
Section 3(1), my lord.
No, that legislative council already, there's no issue.
Yes, my lord, because my learned senior friend, my lord, have not read out
That is recorded in
the proviso part, my lord.
166 also. Page
There
166.
is a proviso, my lord.
Third para.
There is a proviso, my lord.
Yes.
Provided that the order of such permission, recognition, affiliation, concurrence, etc., shall have to be issued on or before 1/1/2006, and any order issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teachers and tutor, as the case may be. So it has to be issued prior to 1/1/2006. So as on today, my lord, they do not have the order of permission, my lord. So since they do not have the order of permission, so under this Act of 2017, they are not eligible for consideration for.
It said they've been running it since 1995
There is-
to 2005.
We are not disputing that, my lord. What I am trying to impress upon your lordship, that under the provision of 2017 Act,
That's why the legislative council technically is correct that there is no permission. as
if it
such.
is technically correct, then the finding of the director is also technically correct, because as on today, my lord, 1/2006,
But
they
at
have,
least the recommendation part is not correct.
that is not correct, my lord. That is not correct, my lord. But as regards the provision of law it is correct, my lord.
Let's see. I'll apply my mind.
Yes, my lord.
What relief can be granted?
Yes, my lord.
Not this proviso.
Sir,
which
it's
my-
only,
my-
they admittedly, there's no permission.
Ah.
So it is
No,
recognized.
no,
it
no,
is
because there is
admitted
a
that-
permission, but that permission was sought to be cancelled. That's why I said, my lord,
Let us see
that
where
requires
the- where is the
interference.
Permission.
Yes. Permission is at 94, my lord, page
94.
94. And now they want to say that this is not permission by letter at 1 second, my lord. No, 94 this is delay. এটা সৰু order এটা আছিল নহয় বুলি
Son of my hands.
1 second. sir.
Last one.
Yes.
One.
Well, 110. Please come to page 110, my lord. Lots will have to interfere with this order also. In fact, we have challenged this order also. With reference to the above, I am directed to clarify that government letter dated 22/4/21 is not a permission in respect of the 20 number of higher secondary schools as mentioned in your letter under reference. My lord, government could have simply said, we are not granting permission. Why he wrote one whole page, my lord, at page 94? That itself shows, my lord.
This letter is page 94.
Yes,
This
page 94.
24.
And subject is according of departmental permission to open first year higher secondary classes. In this order itself, my lord, the additional secretary takes note of the fact that these classes were started in 95, it's open between 95 and 2005, and till that they're running as venture school. Now, last para. In view of the feasibility report issued by the Assam Higher Secondary Education Council, together with your proposal for according permission to open first year higher secondary classes by your letter under reference during pendency of the matter may be attended, and steps should be taken to invoke provisions of relevant rule in force in respect of the matter of permission as prayed for by the 20 schools. So that means, my lord, when provincialization is permitted, that means permission is there. Now, this order is sought to be nullified by page 110. So that's why I said, my lord, lordship will have to interfere with page 110, 167 and 171 and remand the matter. That is my respectful prayer. Let them take note everything, my lord. Let them take a holistic view of the matter. End of the day, my lord, students are studying. These people are working from 1995. As such, my lord, these are hard days of employment. So, my lord, government will take a compassionate view of the matter.
Still 20 schools are running.
Yes. In fact, students are appearing in higher secondary final. That was also sought to be stopped, but by virtue of interim order, my lord, that registration was permitted. Now they are appearing in exam. And that proviso has to be given a meaning, my lord. Lordship will not give a meaning to the proviso to, I mean, if there is any, my lord, there are two views possible. The view which favors the, my lord, applicants, that should be preferred.
Yes.
But I'm relying on the, in fact, impugn order and what transpires that.
You rely, but justified.
Yes, my lord. What transpires is that, my lord, as on today, they do not have the recognition. If we consider that they have the permission on 2021, that also qualified them to be provincial under the 2017 Act. Because, my lord, it has to be before 1/1/2006. But if we are going to the page 110, my lord, 110 and 94, that if we consider it as a permission, that is also given in the year 2021. So it has to be before 1/1/2006. So in that event also, my lord, they are not eligible. So that is my humble submission, my lord.
These petitioners are the honor of the schools.
Lord,
Petitioners,
the petitioners,
Arjun Das and 26
yes,
others.
these are all these teachers, my lord.
Teachers, okay.
One,
This is
two,
from
three,
teaching and
one,
Teaching and non-teaching.
Acha, acha. Okay.
NJ.
Teaching and non-teaching staff. my lord. Those cases were recommended by the district level committee.
Administered. Can show the senior counsel assisted by
Devi.
K.
Devi.
P. Devi.
K, my lord. K
K.
for Karnataka.
MS. K. Devi. Then counsel for the petition. 5 to 10, huh? It will 5 to 10.
Even we will go over here.
And
Is NJ Khatuni, madam.
standing counsel,
Standing council, secondary education. madam.
secondary.
My lord, I am for respondent number 4 and 5, my lord. TK road.
Anything to say?
My lord, as per revised regulation on recognition of higher secondary schools, my lord.
You are for council?
Yes, my lord.
Yes.
My lord, as per clause, my lord,
Hmm.
the government approval is required, my lord.
Right.
If government approval is there, we have no objection to permit them to start class 11 or 12.
Right.
Only.
How the approval has to be granted?
Yes, my lord. My lord, kindly. My lord, at page 2, my lord, of our revised regulation on recognition, my lord.
Mhm.
Clause 1, my lord.
Yes.
Application for permission to start a higher secondary school or junior college. When it is proposed to establish a new higher secondary school or junior college or to upgrade an existing high school already recognized by the Board of Secondary Education to a higher secondary school or to open a new stream or subject in an existing higher secondary school or junior college recognized by the Board of Secondary Education or the Assam Higher Secondary
Where you are
Education.
reading?
My lord,
Page
at
two.
page 2, my lord.
Page 2.
Yes, my lord.
Ah.
1, my lord, clause 1. Below, my lord.
Application permission.
Yes, my lord.
Ah.
My lord,
Start a higher secondary school, junior college. huh?
yes,
When
my
it is proposed to, huh?
when it is proposed to establish a new higher secondary school or junior college or to upgrade an existing high school already recognized by the Board of Secondary Education to a higher secondary school or to open a new stream or subject in an existing higher secondary school or junior college recognized by the Board of Secondary Education or the Assam Higher Secondary Education Council, as the case may be, the sponsoring body shall submit an application to the Secretary, Assam Higher Secondary Education Council. Such application shall be made in the prescribed form number 1, 1B and 1C, according to the applicability, and must reach the council not later than 31st of March of the year in which the classes of the HH school or junior college are expected to start. A copy of such application shall be forwarded to the concerned directorate. Thereafter, my lord, in case of existing government and provincialized high school, HH school recognized by the board or council, the sponsor shall be the Govt of Assam. My lord, sponsor shall be the Govt of Assam, my lord. Application for upgrading, starting additional stream or subject shall be made by the headmaster or principal of the institution concerned, together with a copy of the government order to the effect, my lord. So government order is required, my lord.
So,
in case of the petitioner, there is no any prior permission from the government. That is from the Director of Secondary Education, my lord. If they have the prior permission, we have no objection, my lord.
Hello, para 5 of the affidavit in reply, we have explained the whole position. Para 5 of our affidavit in reply.
you have not filed affidavit.
Yes, my lord. Today we have received the signed copy of the affidavit, my lord.
You have what you do. We'll record your submission.
Yes, my lord, kindly.
Based on the affidavit. Just give it. You have not filed it.
Not just today we have received the signed copy, my lord.
Can you make it formally filed then? We will not hear you. I will not, we will the argument.
On my lord,
On
Monday,
Friday, next Friday.
on Monday also, my lord, or Tuesday, my lord.
Friday, no, Monday,
ठीक है, sir.
Let it Friday.
Make it,
Let it Friday.
We'll just keep it part heard, but
Yes.
then we'll not hear further
My
argument.
lord. Yes, my lord.
Hearing concluded.
Yes, my
Deeply.
lord.
The
এখন লাগিব। এইখন নহয়, সেইখন।
Mr. So and counsel for the petition, the respondent number 3 and 4.
4 and 5, my lord.
4 and 5. Is granted. 5 days time to file his affidavit. As according to him, the affidavit is ready.
Ready, my lord.
Which he would be filing. Within 5 days.
Within, yes, my lord.
He would be filing.
File it by tomorrow, my lord.
Shortly. All right.
Yes, my lord.
Accordingly, list this. List the matter on matters on. Wait.
Friday.
28/03/2020 as a part heard.
Deeply. Oblige, my lord.
With an understanding that we'll not hear,
My lord.
no further hearing.
My lord.
Only to bring on that. Yes. Yes,
We have received one instruction, madam,
one instruction all.
of not
Complete
for the,
instruction.
madam, that is gazette notification of releasing the releasing that area portion, madam.
Context in. Yes,
This is the second,
No.
thing,
no record. Only handing over.
only, madam, this is the gazette notification of, madam, kindly see the last page, my lord.
Hmm.
In last para notification, New Delhi dated so and so. SO 229, last portion, my lord.
Yes,
In
yes.
exercise of powers conferred by the
Section
Section 5 of National Highway Act, the central government hereby make the
Amendments.
following amendment in the notification of Government of India in the Ministry of Shipping, Road Transport, Highway, dated 25th May 2007, namely, in the table of the said notification, the enter in respect of National Highway number 44, that is in respect to the petitioner, and the enter relating thereto is column number 1, 2, and 3 shall be omitted.
So you are no longer,
Yes, ma'am.
because this, in this entries, the land of the petitioner,
Petitioner will enter National Highway, his land is in National Highway 44, my lord.
Yes.
Lord, in as part as notification entered in respect to National Highway 44, my lord. Only this must we receive.
yes,
Okay, okay.
So far as my instruction is concerned.
well, it's a national highway, no?
Not National Highway Lordship. It was handed over to us by the BRTF Lordship, NH 44.
Hmm.
So for from the whatever instruction I received, Lordship, it is not at all clear whether it was handed over to us for our use or it was for the purpose of returning to the petitioner, Lordship. And the requisitioning authority is DC.
DCS. DC, yes, DC was the requisite.
Yes.
DC.
DC. But presently it is in our custody, Lordship. We are looking after the land, but
Is it of any use
no, no,
for the PWD?
not clear, Lordship. Lordship, in fact, it was no longer of their use, Lordship. That is why they handed over it to us. It was for custody or for our use, Lordship. That is not clear in that notification. But we are not
So
basically,
according to you are not using.
we are,
It's of no use for you.
Lordship, we are dumping some articles there,
Ah.
but not for the, that we are using.
It is not.
It is just empty because that is why we are
It's
dumping
not,
some.
it is not been used for any public purpose.
Yes.
Just because it has been handed over
But to us, it is with us,
you.
that is why. And in fact, Lordship, in 2022, we sought for clarification from the Deputy Commissioner
Hmm.
as regard who is the actual patedar of the land also, Lord.
Ah.
Subsequently, they informed that land mentioned below is found to be recorded mutated in the name of Motilal Bhor, son of late Mahadev Bhor, through purchase right by number so and so 1989.
So there is no dispute about the ownership.
Now, Lordship, it appears it's the Deputy Commissioner's letter, Lordship. They clarified that Motilal Bhor was the registered owner of that.
Our father.
Father of the petition.
What is the area of the land?
My lord, our area, my lord, it is, our claim is, my lord, 2 bika, 14 kata, 12 chatak. Duct number 288 and 293. It is already, this court is recorded, my lord, this order in here. So our only prayer, my lord, whatever the due rent since 2005, that may be released and our land may be handed over to us, my lord.
Oh, that is the difficulty. How this was, whether is there any provision for paying rent and other thing?
Lordship, in my WPC page 20, annexure 7, it's a letter from additional deputy commissioner. Kindly have a look, my lord. Page 28, annexure 7.
Page
28, my lord, annexure
28.
7.
Yes,
Yes.
collector.
Yes, my lord. It is written, my lord, to the officers commanding so and so commandant that with reference to subject cited caption above, I am to inform you that the land measured because so and so category has been under your possession and was proposed for acquisition in favor of the dependent. It is reported by the owner of the land, so and so, has vacated this land. Since the National Highway Authority, Barak Valley, had been handed over to the State Public Works, the PWD, and requested to relinquish their land and to hand over the land to the Pattadar. In view of the above, you are requested to give your views regarding relinquishment of land and handing over the same to the Pattadars and the land.
Yes.
Subsequently, another letter issued, my lord, at page, Lordship will find at page 31, annexure 10. Additional DC wrote again the PWD. The earlier one to the commandant, this is the PWD.
Page 31.
Yes, my lord. That is on 27 February 2019.
Then
With reference to the subject cited caption above, I am of the inform you that the land measuring because so and so possession so and so, the said land was vacated by the BRT authority and handed over to the PWD. I requested to relinquish their land and handed over the said land to the Pattadar. In this connection, you are requested to submit your views regarding all the time. Only they are seeking sought by the additional DC from the Union Authority or from the PWD, my lord. And neither since 2005, not even single payment has been made to us. And when and why they have really handed over the PWD if it's not known to us when we came. And now 2025 is going on, my lord. Our only humble submission, my lord. Another letter, my lord. Page 33 wrote, the PWD wrote to the additional DC, page 33. Annexure 12. Our final and last page, my lord. The last bottom line, my lord. Under the above circumstances, the claimant Pattadar may approach to justify the claim with all specific relevant papers, including agreement copies with the BRT, so as to enable the undersigned to appropriate action in this regard. That means they welcome to us. You come with all testimonials.
You
We'll-
only ground that it has been forcefully taken and used by the BRP.
Even my learned
And
friend
now-
said that they are not using me lot.
Now,
Some dumping
now this has been handed over to PWD.
PW even not using our land, but they are not relinquish our land, either paying rent, not relinquish our land, my lord.
See, suppose, for example, if they want to revert it back, revert the land back to you,
Yes,
what would happen?
we will, this is our land. We are no more willing to further lease with them. Our land we want.
So where is the lease agreement?
Well, it is with, earlier commandant have taken when my father was
Where
there,
it
my
is?
lord.
Where it is?
It is all the testimony with them, my lord. That is all admitted fact. They are not disputing, my lord.
Where it is? So
In the all communication, it is there. They are not disputing.
Anyway, I'll ask them.
Yes, my lord. We'll
Suppose
approach
today
before.
if they want to hand over the land back to you, you are
My lord.
ready to accept?
My lord. Lordship may have directed, my lord.
No, just wait. Are you ready to accept the land?
Yes, my lord. As per my instruction, my client, they're ready to get their land.
Okay, then whatever, anything else? That's all.
My lord, the rent due to me since
For
2005.
that, you have to show something. Was there any agreement? Was there any, I mean, kind of any?
My lord, admittedly, it is established before this court. In 2014, my lord, the union has the land with them, my lord. That is true. Then 2014, but though PW is not aware, they are not disputing that.
So happened that you have just allowed them to use the land.
Why should we allow, my lord? Why should they? Since commandant, they are using our land since 2014.
So since you are using it land 2014.
Yes, till
Since
2014.
when?
My lord, since 1964, my lord. Since
So,
2005, in 2025, 2005, we have
14.
received rent, my lord.
Huh?
2005, we have received rent.
Okay.
Then, my lord, since 2005, this Honorable Court is recorded, my lord. There is on from 5th August 2005, there are no more rent from there onwards, my lord.
For how many years you have received? For how many years?
64 to 2005.
Okay, then
Then 2005, not even single payment made.
till 2014.
2005 to till date.
Okay. So on what basis you are receiving the land? I mean rent?
Since we are the owner, my lord.
No, any agreement, any documents to show that on
Since
how it has to pay?
No, no. No, since
Any
it is a
terms and
testimony, it is a
condition, any-
testimonial, the officials, they are concerned, they are taking our land, they are using our land, they're supposed to pay our rent. This is not disputing 2025, they are receiving our land. So it
No,
is,
that's a reason why I'm asking. Suppose the rent has to be paid either under any law or the rules or by agreement, right? All right,
my lord.
any compensation, any rent, whatever lease rent, whatever is there, it has to be based on some agreement or some kind of the orders.
My lord.
Suppose a compensation has to be paid. The acquisition has to be made under certain act, certain law. And lease rent also, if it doesn't provide, by way of agreements also you can have the enter into an agreement. On what
lord,
basis you have
They,
been,
my lord, in 1960, while our father was there,
just
my lord.
wait, let me complete.
Yes, my lord.
On what basis you are receiving the land rent up to 2005?
My father was there, my lord. My father expired, my lord.
Okay, your father on what basis he has received
They acquired our land, my lord.
acquired land?
Yes. They acquired our land, my lord. And
If it is acquired, what provision acquired? It was acquired.
it was acquired, my lord. In the, there, kindly have a look at, my lord. My lord, Annexure 1, page 20. This is the letter of 1964. Kindly have a look. To establishment of AECO headquarters. Annexure 1, my lord, page 20. By the Deputy Commissioner Kasak Silchar.
Acquisition,
Yes.
not acquisition.
Acquisition, yeah. Taken over by the Serencho requisition, ban Silchar immediately,
the compensation payable to the owners will be determined in due course.
Yes, well, the
Then, my lord, page 21, annexure 2, this is a rent received.
page 22.
Page 21, my lord.
So you have received up to
Up to, my lord, lordship will find page 22 in the right side, my lord, 5/2005. 4,562. Land acquisition collector Silch Kasar, they have paid to us. Thereafter, my lord, kindly have a look, page 23, annexure 3.
it's okay.
Yes. Then, my lord, ultimately, this way is going on, my lord, 2024, 14, when they have given to the NPWD, we don't know, my lord. And then, my lord, 2024 onwards, the PWD using that land, my lord. Then,
Why you were silent
Where-
since 2005?
no, my lord, we
2000
continuously were making representation before the authority, my lord.
Since when?
Yes, my lord. Since 2014, page 27, annexure 6.
Then 2005.
2014, my lord. 2018, my lord.
No, 2005, 45 to 10.
My lord.
In between 2005 to 2010. I mean, 2005 to 2014. Years.
Even
Eight-
page
what-
25,
what 8
even
years?
page 25, my father even wrote letter, my lord, on that is on 2010. It is there, my lord. 2010, my father Motilal or even wrote a application before 2010, 2014, 2018 on the. They are not disputing that we are not on our. They're using our land. They are taking land. So we are entitled to the land as well as the. We'll then get back our land. That is the. They are not disputing. They are ready to give us the land. So we show our. We will appear before them. They will examine our claim. All the records, if we're actually owner of the land, let them relinquish our land, my lord. And whatever the amount we're entitled, let them examine how much we entitled, then calculated them.
Where is the provision for relinquishment after requisition? Is that act of acquisition, requisition is still in vogue? Assam acquisition and requisition law is still in vogue.
This is on the national highway.
No, initial requisition was under Assam.
Initially, that's 9 to 9.
There is no acquisition under the highway act.
But in their affidavit, lordship, it is mentioned as acquisition.
Anyway, no, I'm asking whether it is under the, still, that acquisition and requisition is under still, it's still there. Initially, DC has requisitioned the land
Yes.
under that act only.
Yes, yes, my lord.
And what happened in the due course, you have acquired the land under highway.
My lord, requisition and acquisition of immovable property act 1952. There is an requisition and acquisition.
Page 18, what is that first page? Yes, mister, this
Hello.
page 20. Assam Land Requisition Acquisition Act 1964. It's still in vogue. Yes,
Revenue.
it's still there. That's why I'm asking whether is there any provision for relinquishment? Like section 13, section, the provisions of 2013 Act.
As
my
per
lord.
revenue.
My lord, will give some, this honorable code on 5th Ward 2020 for certain observation made, my lord. Kindly have this order, my lord, in paragraph 4, certain observation made on 5/1/2024 by this honorable.
But finally, taking up the matter, why should go back for all those interim orders? Yes, where it is?
My lord, in 5/1/24, lordship have a single paragraph 4.
5/1?
5/1/24 order. My lord Justice, Honorable Justice Manish Chaudhary, my lord.
Yes.
Yes. This honorable court recorded all the facts, especially my lord, paragraph 4. In this petition, the petitioners with the above facts have contended that during the period within which the parcels of land were under requisition from 2004 onwards, the petitioner had received the last requisition rent up to 5 May 2005, and memo disbursing requisition rent did not also disclose the period. Subsequent on 5/2005, the petitioner did not receive any requisition till rent till date. From the above conspected of facts, it appears prima facie that the parcels of land of the petitioners mentioned above have not been acquired by following any valid process of acquisition, as the respondents till date have not brought anything on record as regards culmination of the land acquisition process initiated by LA case number so under the Land Acquisition Act, since an amount of rupees so stated to have been deposited by the respondent authorities in the Union of India, and the said amount has not been disbursed by the Deputy Commissioner Kasar to the petitioners till date. It is not possible for this court at this stage to arrive at a final opinion. Ultimately, let them were directed to file affidavit in this regard. And as per affidavit filed by the union, they have said that they have this amount they have deposited before the Deputy Commissioner, and Deputy Commissioner counter affidavit filed. They have said that we have not even single payment we have received. Then again, the Union of India, another affidavit filed, they have said that yes, we have deposited. This is the tussle between the state and the union. Why should we suffer, my lord? This is that so far that amount.
Otherwise, that amount is there.
My lord, that amount they have issued for the.
This is for
compensation. Compensation, but this is not a case of compensation. This is a case now with the rent, but due rent as a relinquish of a land, my lord. My learned friend may highlight on this point, please.
Well, kindly see page number 84, my lord. Here, my lord, we have submitted the check before the DC, my lord. And they have received the check, my lord. But in their affidavit, they refuse.
This is for what? It is
My
for
lord,
rent.
acquisition of requisition plan measuring 5 bighas so and so.
It's for acquisition or
Acquisition.
compensation or requisition?
It is
Rental.
acquisition, my lord.
Huh?
Acquisition.
Initially, the land was under a
Ac-
lease agreement.
Yes, no.
Subsequently, when the petitioner denied to extend the lease,
Then we,
authority proposed for acquisition of the land. Accordingly,
Okay.
amount was also deposited with the deputy commissioner.
yes, no.
Thereafter, Lordship, in the 2015, it was handed over to the PWD by the BRTL, not by the deputy commissioner.
So there is no question of relinquishment. Since here this has been acquired.
So neither acquired nor acquisition. It was under a lease agreement.
Initially, it was under
A
this
proposal
agreement.
was definitely there. One LA case also was there.
Like we have
And
stated, I think,
amount was also deposited with the deputy commissioner, but that was not never awarded to the petitioner. So it was only a lease, case of lease agreement.
yes, before 2000, email, before 2003, I think. It was the case of lease
Correct.
agreement,
Lease-
before 2003.
And thereafter,
Thereafter, my lord, we, because they refused to give, extended the lease agreement. So they, proceeding for acquisition had started, my lord.
that
after
has not been brought to logical conclusion.
I think, my lord, that may be, my lord, that DC may, submit
What
that.
about the LA case?
LA case,
Like
my lord,
open,
DC. And for that, we have already submitted, for that acquisition process, my lord, we have already submitted 6 lakh something, 35,665 to the DC, my lord.
2003,
2008, my lord.
2008.
Yes, my lord.
Yes, what happened to that LA case? Saying what? Yes, page.
Page 70.
Ah,
Here we have selected the compensation to the Pandana not be paid as the requiring department reported the estimated amount at the disposal of the collector.
so
And also, in paragraph 3, we have stated that the reported the consultation of
page,
same page 70, paragraph 8,
70,
70,
para 8.
para 8.
70, there is no para 8, this Roman 8. This is the problem.
Academic filed by the P&4.
See, pagination are not, is different.
এইখন দি দিওঁ। ভাল, এইখন দিব পাৰে, মোৰ কপি আছে, এইখন চাব পাৰে। পাইছে কিন্তু।
No, this affidavit is there, but then pagination is not.
It is my copy, my lord.
No, no, this, they are there. If it's here, why I should unnecessary? Otherwise, so many affidavits. 68. I mean 70. 70, there's nothing. It's in Roman, then it's, this is where. Affidavit is filed by respondent number 1, 7, and 8.
3 and 4.
Date to koi কোন তারিখে পেন
Respondent number 3 and 4.
3 and 4, my lord.
If you start from page 75. How to rectify this? It's not one cases, all the cases, one case. There's huge difference in the pagination. How do you manage? Who is the person who should deal with all this? Section officer. How they paginate? They themselves paginate it all. Huh? The lawyers? No, in that case, they should also be there, no? They should also inform. Huh? See, they have shown that the money has been deposited.
We have stated that the requiring department did not.
You are saying will not do, they have given the receipt.
Then I have to take instruction on this because in paragraph 8 also.
So, it's all right, if it's not, they have not deposited. So what about the LA case 6 of 2023, 2002-3?
Our affidavit does not cover that aspect regarding that elective.
No, obviously, according to, if it has not been deposited, must not have been completed.
Paragraph 8, we have stated about one communication to the BRTF authority. On 4/8/2014, but no response has been received for the requiring department. Paragraph 8, we have stated.
Have you furnished the copy
Which one? Yes, my
to
lord.
Deputy Commissioner?
Yes, my lord.
Then, what is your response? How Mr. So and so, you obtain instruction
Yes, my lord.
after 2 weeks. We'll have to clarify the facts first. There's a claim and counterclaim between them.
But this is a land
So
acquisition.
and so, land counsel for the petitioner. And having considered the submissions of land counsel for the land CGC,
Yes, my lord.
that the compensation, the amount of compensation has already been deposited before the Deputy Commissioner, which district?
Kasar.
Gotcha.
No, as in the-
On when?
My lord, on. Yeah, even- On 8 April 2008.
On so and so, by the BRTF,
Yes, my lord.
which, the acknowledgements, which has been duly acknowledged by the office of the Deputy Commissioner. And the contrary statement, the stand of the Deputy Commissioner, that no amount of compensation has been deposited by the BRTF. Learned Council for Mr. S.R. Borwa, Learned State Council, appearing on behalf of the Deputy Commissioner. Gotcha. Is granted 2 weeks time to obtain instruction. Matter remains part, continue to be remain part.
But ultimately, my case is, my lord, the gentleman rand
Thank
as a
you.
relinquisher for land, my lord.
Yes?
So that is,
No, again, before that, huh? Yes, before that, after hearing so huh? The, as per the, in terms of the order dated 04/03/2025, Learned Council, MSA Gyan, and Mr. P. Nayak, Learned Standing Council, PWD, and MSA Gyan, Learned CDC. By placing the respective instruction. The, as per the instruction, no, as per the instruction, the instruction, please, the above instruction indicates that there is no record to show that the land has been de-requisitioned by the authorities.
Or under use of the PWD.
It's okay. We are not recording that now.
Master Black.
Then you write them, huh? So and so, huh?
Oblige me.
Yeah.
Your Lordship. Today, my lord, I am seeking apology, my lord, for my senior lordship. Last occasion also, I make a pair similar, my lord, today actually senior. My lord, so I pay for on Monday, my lord.
Tomorrow,
Tomorrow, my lord, he will buy, my lord, he will be out of possession, my lord. Again, I have to get a job, my lordship. On Monday, lordship, as a part of.
Have you taken any instruction from him?
Lordship?
You are good at method. What's
No,
the?
my lord, my senior, I do, my lord, on Monday, my lord, we do, my lord. Tomorrow, my lord.
Have you taken any instruction that which post the petitioner is now?
My lord, petitioner already retired, lordship.
Retired.
Only our claim is for no.
So what is your prayer here? Direction towards directing response to effect the promotion petition of the cadre of Joint Secretary with effect from 01/02/2014.
Yes, sir.
When did you retire?
Retired lordship, after 31/3/2014 lordship. Writ petition file on 25/3/2014 lordship.
After retirement?
No, before.
You retired on?
Retired on 31/3/2014. Writ petition file on 25/3/2014.
25/3/2014.
My lord, the post in which my lord, the petitioner claimed by the
post poll value.
Yes, on 28/1/2014, my lord, post is vacant now.
On 28
1/2014.
Okay. So according to you, before your retirement, you should have been promoted.
Yes, lordship.
The moment the post fell vacant.
Yes, lordship.
What is the law?
Lordship.
Even if there is a
on Monday, lordship.
normally they should.
Yeah. On Monday, lordship, my
The vacancy and all this they have to work out. But
Yes,
then
sir.
if it is not,
Lordship.
because right to consideration is a fundamental right, not the promotion, right to promotion.
Right to consideration is the fundamental right.
It's consideration. It's a matter of few months.
Lordship.
How do you expect? You retire on 25, 35,
31/3/2014.
2 months, 3 months only.
Lordship. For pensionary benefit, lordship.
No.
Anyway, my lord, on Monday, my lord.
Tomorrow.
Tomorrow, my lord, my senior out of
Where he is?
My lord, he's my lord, today also out of business.
Itanagar.
No, my lord, he went to Dibrugarh, lordship.
Dibrugarh. You make a call, you prepare the method.
My lord,
we'll dispose it.
kindly, my lord, Monday, my lord. As a may keep this matter as a part
Yes,
also.
one more thing, you are supposed to, there's a requirement of having a work out the vacancy 6 months or 1 year before.
Lordship, we have filed, at that point of time, my lord, the councils were different, but there is, as per record, I've checked, my lord, we've reconstructed the file.
Yes.
There's an affidavit which has been filed by respondent number 3, my lord.
Saying what?
Bringing on record that, my lord, that's quite lengthy, my lord. So, my lord will have it, some hearing is required, so Monday we'll have it, we'll have to prepare, my lord.
Hearing is not required, in fact. That's why we have fixed the method today.
On
Monday,
Monday, lordship, as a part, lordship, fix, my lord, he will my lord.
You retired in 2014.
Yes, lord. Anyway, my lord, on my senior occasion, my lord, lordship.
10 years.
Lordship. No, thereafter, my lord, we are also newly engaged, my lord, last year.
On the prayer of learned council for the parties, list this matter Monday,
Monday.
20.
24.
24.
24.
This of 2014 as a last chance.